Okay, we're going to go ahead and get started. We've got several bills, but I think some of them we've got a lot of people signed up, so we're going to try to get to them as best as possible. We're going to start with House Bill 1014. Chairman Werkheiser. Thank you for being here.
Thank you, Chair Lady Hong and members of the committee. I've got House Bill 1014 and LC is 481086, which has been unchanged. Real quick before I go through the details of the bill, because I can probably describe it just by telling how we got here. In 2015, Georgia executed a man who is intellectually disabled because of the standard of beyond a reasonable doubt. We're the only state in the country that has that standard of the 27 states that allow the death penalty. And we're also the only state in the country that determines intellectual disability during the guilt phase. This bill changes those two items. Intellectually disability would be determined before the trial begins, which separates the issue from the bias of the facts of the case. So it would change it to the beginning instead of the end. The other change, which I've already mentioned, is on line 120, where the defendant is convicted beyond a reasonable doubt of the crime and then is found by preponderance of the evidence that the defendant has an intellectual disability. Ironically, in 1988, Georgia was the first state to prohibit the execution of people with ID, so we were one end of the spectrum and all of a sudden find ourselves at the other end of the spectrum. Unfortunately, when this bill was drafted, we set the standard so high that while requiring injuries to perform the very difficult task of deciding that and when the guilt phase at the same time. For example, in that 2015 case, the defendant, it was not being used as a arbitrary defense. All throughout school was in special ed classes, but with the standard of that we have now beyond a reasonable doubt, when it's something subjective, it's basically an impossibility. So with that, Section 1 is definitions. Section 2 speaks of the court and the defendant making the motion before the court to decide on intellectually disability before the trial starts. And then, as I said, Section 2 changes from, I said Section 2. Section 3 all the way down, really the meat of it is in 120, where it's the conviction is changed to a preponderance of evidence for the intellectual disability part. With that, I'll stand for questions.
Okay, thank you, Chairman Werkheiser. We have a question from Chairman Smith.
Thank you, Madam Chair. Thank you, Chairman Werkheiser. We appreciate your hard work on this. I know you and I have had some pretty good discussions about this, even in the interim. I wanted to ask, I know that this covers intellectual disabilities that have manifested during the developmental period. Had you considered those impairments, disabilities, intellectual disabilities that occur outside of the developmental period?
I have not, but I'm assuming during that, during those first motions, when both sides are there before the court, that the entire scope of whether they're intellectually disabled, whether it was developmentally or occurred later, would be brought up before both sides.
Okay. Just there's a fear that I understand the intent of what you're trying to do here. It's just, what about those that these manifest outside the developmental period? Is that a policy consideration that you would be open to?
I certainly would be. And I'll tell you this, this was a tough bill for me intellectually because of the legalese. And if you look at the 7 sponsors of this bill, they're all attorneys and judges from both sides of the aisle that are very respected by both sides of the aisle. So maybe some of those folks can help us answer that.
Thanks,
But I'm certainly open to a policy change.
Thank you.
Any other questions? All right, and we have several people signed up to speak, so I'm going to go ahead and start calling them up. First one, sorry, I cannot read. I know it's Frank something. Okay. Sorry, yeah, I couldn't, but thank you. Come on up. How are you? Thank you for being here. If you can put one of the mics in front of you. And
If you don't mind, this is Maggie Rousseau, who's listed second on your list.
Okay, sure.
I've invited Maggie to, where do I need to press?
You don't need to press anything. The mic's on.
Okay,
If
sorry.
you can
Okay.
introduce yourself and who you're with.
Okay, I'll start with myself. I'm Frank Bulkey. I'm Executive Director of the Georgia Catholic Conference. I represent the Catholic bishops of Georgia, and we take positions on issues that we think are important to the common good of Georgia. And certainly, the imposition of the death penalty is one of them. And this has been an issue which has been going on for a while. As Chairman Werkheiser mentioned, there was another bill several years ago. I think this is a much improved version. But anyway, let Maggie introduce herself. She's an expert that I am not.
First, I'm Maggie Rousseau. I am the Director of the Disabilities Ministry for the Archdiocese of Atlanta. I'm also the parent of a child who had an intellectual disability and also taught in Gwinnett County and Effingham County in special education for students with disabilities. So I have a long background with almost fairly specifically to intellectual disability. And before I start, I just want to acknowledge and send along our condolences on the death of your colleague, Representative Smith. He was a very devoted servant to the state of Georgia, and so please know that you are all with us in that journey. What I wanted to talk about is that intellectual disability is really an injury to the brain. And that injury can occur either before birth as a genetic disorder, which is similar to what my son had, or it could cause from a trauma to the brain. And the federal definition is from the American Association of Intellectual and Developmental Disabilities. And that definition is that injury to the brain occurred before the developmental age. And that developmental age, again, federally and here in Georgia, is determined to be age 22. So that age is more a matter of diagnosis of intellectual disability, and that developmental period, again, is defined as up to age 22. And I believe the language in the bill represents that. The other thing, too, I think that is important to understand is that educational programs can help someone learn new behaviors and adapt how they act with a disability, with an intellectual disability. But it doesn't mean that the intellectual disability goes away. That intellectual disability will always be present. That brain damage will always exist. And so there could be a cause for someone to act out. In this case, we're looking at, an egregious behavior which results in the death of an individual. And that really is a manifestation of that intellectual disability. Having the ability to actually define that and introduce that at the pre-trial stage is incredibly important. And so personally, I applaud you for authoring the bill and to include that language. And then secondly, I've advocated on this bill really since 2015, and as a mother and a teacher, I just was appalled that we do this. And it was not the intent of the authors of the original bill. The intent was really to abide by the Supreme Court decision and with the Eighth Amendment to not have cruel and unusual punishment. So we're rectifying language that was just misinterpreted, and we're protecting the most vulnerable. And of course, as they go through the trial and are convicted, it doesn't mitigate the crime or the anguish that a family feels. I personally have a friend whose daughter was killed in downtown Atlanta at age 18. She was murdered, and she begged the district attorney at the time to not go through with the death penalty because she felt that her daughter's life wasn't worth the life of another person. That was her personal belief, her religious belief. And I personally, having my son passed away, with disabilities passed away a few 20 years ago or so now, and I can't imagine as a family who has lost a child having to keep reliving that over and over and over again till we get to the end of that death penalty decision. And so I just want to personally say, and also as the Director of the Disabilities for the Archdiocese of Atlanta, please look carefully at this bill. Please consider supporting it. And please, we are a pro-life state. We've done such a good job to become a pro-life state. Let's make this another good pro-life decision. So thank you very much.
Thank you for your testimony. I think we have one question. Is that Representative Gullett?
Hey, thank you for your testimony today. Do we have any idea of how many people that would fall under this in Georgia have been executed? Who have been disabled? I know there's one case that the sponsor has mentioned, but do we have any idea how many this would affect if it had been in place?
I believe Kathy Harmon Christensen from Georgia's Alternative to the Death Penalty could speak more precisely on that than myself. But in recent years, my understanding's been there have been about 14 individuals who have been executed who would have been identified as having an intellectual disability. I do know that we have never in our history as a state waived that execution because someone posed the defense of an intellectual disability in that hearing phase. The sentencing, right now it's during the sentencing phase.
Thank you.
If I could add just one point to that, as I understand, many of those who have been convicted of usually murder, in this case, if you go back in their history, we don't have the tools in our educational system that we have today, that we could diagnose a child with intellectual disabilities in a very accurate way, which we could not have done 25 years ago. So we're moving, I think, in the right direction with this bill.
And if I could just add to that, my experience with other state agencies is their policy is not to keep records after 10 years. And so where I've gone to try to advocate for individuals to help them in their disability waiver applications or in terms of just helping them reestablish a previous diagnosis, agencies like Voc Rehab and the education high school departments don't keep that information. And when I testified last year, I thought about it myself as a parent. Who tells you up front when your child is in an IEP meeting that you better keep all these pieces of paper because there might be a time when they're 30 or 40 or 50 years old that you're going to need it to go and take to court to help prove that they had a disability. So, and then again, that's just something else to consider.
Great, thank you. And there are no more questions. Thank you.
Thank you.
Thank you very much.
Thank you. Colin Larson. Thank you. Good afternoon.
Good afternoon. Thank you.
If you can state your name and who you're with first.
I'm Cullen Larson. I'm here as a citizen. I live in Forsyth County. I'm a Catholic, and I associate myself with the testimony of the first three witnesses that you've heard in favor of this bill. My background includes service as a county attorney in Lumpkin County, and when living there, had a very good couple of friends who we chose as the godparents of our first son. Years went by, they were shot and killed by their daughter-in-law in Hall County. I lost two wonderful people, friends. So I don't come to this issue easily, and I come to it with some experience. That it falls short, my experience does, of some other people, but I think it's valid. I also have a person with intellectual disability living in my home, my sister-in-law. And so I have some personal knowledge of that. I want to thank you all, Mr. Chairman, for those of you sponsoring and speaking for this legislation. As a Catholic, as a Christian, as a person of faith, as a citizen, I want Georgia to be the best it can be in the administration of justice. I know you share that desire as well. Whenever there's an opportunity for an incremental improvement in the way that we administer justice in Georgia, you want to step up. I do. And House Bill 1014 is one way to make that improvement, and I urge your support. Be happy to answer any questions if I can. Thank you for your time.
Thank you. We appreciate your testimony, and we don't have any questions. Thank
All right,
you.
Thank you.
Dr. Kathy Harmon Christian.
Good afternoon. Well, it is wonderful to be here. I am Dr. Kathy Harmon Christian, and I am the Executive Director of Georgians for Alternatives to the Death Penalty. We are a nonpartisan nonprofit, and we seek fairer ways to administer Georgia's justice system, which, as Cullen just said, I know you all share this with me. And one way we can improve the justice system is to pass House Bill 1014. As Representative Wertheiser said, we are here because we are the only state that has such a high standard of proof to determine intellectual disability. We are also the only state which determines intellectual disability during the sentencing phase, and we need to change this. This bill has been carefully crafted by many people working together who care about this issue. So today, I'll make it short and sweet. I just urge you to pass House Bill 1014, and I'm happy to answer any questions.
Great, thank you. There are no questions.
Okay.
Thank you for your testimony. Sheila Ross, Robert Smith. Oh, didn't see you behind the.
Gotta love 132. I'll go first.
Okay.
I'm Robert Smith. I'm General Counsel at the Prosecuting Attorneys Council. With me today is Ms. Sheila Ross, who's our capital litigation expert. And Ms. Ross is much better versed than I am talking about the procedures and the processes. What I want to talk to you about briefly is, and with respect to the chairman who brought the bill, we haven't had a chance to discuss this in depth, and I know this is the beginning of a long conversation, and a conversation that's been taking place. But I want to introduce you to Warren Lee Hill Jr. And in 1990, while he was serving a life sentence for the murder of his girlfriend, he murdered another person in prison. Using a nail-studded board, he bludgeoned to death a fellow inmate. While his victim slept, Hill removed a 2x6 board that served as a sink leg in the prison bathroom and forcefully beat the victim numerous times with the board about the head and chest as onlooking prisoners pleaded with him to stop. Hill mocked the victim as he beat him. Even locked up for jail for one murder, Hill continued to kill. When he was tried, he did not assert he was mentally retarded or had an intellectual disability. Neither at the trial nor at the appeal, the direct appeal of his conviction for his second murder. Didn't do it the first time, didn't do it for the second time. He did not raise any issue about his intellectual disability until after he appealed and applied for what's called habeas corpus relief, which means the original direct appeal of his second murder case. And at that time, he raised it for the first time. That decision was vetted carefully by the court, and the court found that based on his extensive work history, apparent ability to function well in employment, disciplined savings plan to purchase cars and motorcycles, his military service, his social life, his weak but sufficient writing skills, his ability to care for himself in home living except in periods of stress, and his health problems which included seizures. The court found that he did not have an intellectual disability and denied his relief. That decision was reviewed not just by the Georgia appellate courts, but also by the federal appellate courts. And they found that he did not have an intellectual disability such that it would prevent his sentence from being carried out. I've read to you from Hill versus Humphrey, which is found on Lexis, which I know you have access to, at 662 F3rd 1335. It's certainly, Hill versus Humphrey, Humphry, 662 F3rd, F period 3D, 1335. It's a 2011 decision from the 11th Circuit, United States Court of Appeals. I just want to make sure that the record's correct when we talk about, making assertions that the state has executed someone who had an intellectual disability, or that there are large numbers of people that are currently on death row. We aren't the experts on that. We're the experts on the front end when it comes to trying cases. The Attorney General's office has a unique, specialized group of experts. They're not here today. They're the ones who are much better in tune with the various habeas corpus petitions that are being filed, and the litigation over those, and how that is very specifically designed most of the time to discuss these mental conditions and these intellectual disabilities. We know about it on the front end, and that's what Ms. Ross is going to talk about next.
Good afternoon. I would like to start by addressing our current system. And our current system has evolved from a 1988 statute that this body passed that provided that Georgia will not and should not and cannot execute intellectually disabled people. We actually beat the United States Supreme Court and every other state in the nation in that passing of that statute. The United States Supreme Court did not make that determination that executing the intellectually disabled was unconstitutional and in violation of the 8th Amendment until 2002. So that's how far ahead our state has been on this issue. This is not an issue of executing the intellectually disabled. What this bill is addressing is who gets to decide it and how it is decided. And I'm not talking about deciding who is intellectually disabled in a vacuum or who is intellectually disabled and deserves services at school. This is a unique set of individuals who have been charged with a capital felony, specifically a capital murder, so a murder in the state of Georgia with aggravating circumstances, because you can't seek death on just everyday murder. It has to be an aggravating murder. And they claim that they are intellectually disabled. That's the posture that we're in when we litigate these cases. Our current system, which is 17-7-131, which has been here since 1988, provides, yes, that the defendant bears the burden in that unique circumstance that I just described to you. They've been charged with a capital murder. They are facing the death penalty. They claim that they are intellectually disabled. They have to prove that they are beyond a reasonable doubt. That is the standard that the statute holds. And that process is made by a jury, or that decision is made by a jury of their peers that is carefully vetted in a very lengthy voir dire that is not in place for regular murder cases. And after the jury is seated, then in the guilt-innocence phase of the trial, if a defendant claims that he is intellectually disabled, then the jury, as a fact finder, will decide whether they are guilty but with intellectual disability. If they make that determination, then the state does not go on to a sentencing phase of the trial, because just by way of an explanation in a death penalty case, it is a bifurcated proceeding. And that's the statute that has survived many constitutional challenges. And what happens is the jury is seated. That jury first decides whether the defendant is guilty or innocent, and then if they find the defendant's guilty, then they go on to a sentencing phase. So that's our current position, or our current statute. Our current statute has survived numerous constitutional challenges. It is more and hotly litigated. I'd say you would have to struggle to find something more heavily litigated in our nation than our jurisprudence and our statutory schemes with the death penalty. And I'm not saying that's wrong. That's the way it should be. And that's the way it has been here in our state. And our current scheme, statutory scheme that I just described to you, has been upheld over and over again, including in the context of individuals who claim that they are intellectually disabled. The most recent ones, Young versus the state at 312 Georgia 71, a 2021 decision by our Georgia Supreme Court, where this exact issue was raised, litigated, briefed, and denied. And it was two-part. It was the burden is too high, and the fact that it's decided in the guilt-innocence phase of the proceeding.
I'm sorry, what was that citation?
Sure, it's 312 Georgia 71, 2021. And in the federal system, Rollerson versus Warden, RAULERSON v. Warden, 928 Fed 3rd 987, a 2019 decision by the 11th Circuit Court of Appeals, also passed on this very issue. Whether Georgia's current statutory scheme for determining whether an individual meets the criteria of intellectual disability under this unique context where they are faced with a capital felony is constitutional, and the 11th Circuit Court of Appeals has upheld the statute. They also, that exact case has been denied cert by the United States Supreme Court in Rollerson, and the United States Supreme Court denied cert in Young. So our current statute is constitutional. And I'd like to talk about some of the things that I've heard just a minute ago. I understand that some people feel the burden is too high. Can I say it? Personally, I think it is, we can change the burden. I don't think it matters. And if you want to just change the burden from beyond a reasonable doubt to preponderance, that's easily done by just substituting the words in the current statute that we have. But what this bill does is far more than that. And what this bill essentially does is creates a quadricated process that never ends. It is a non-stop litigation cycle of whether this person under these circumstances is intellectually disabled, and the only way off is for a fact finder to find that they are intellectually disabled. And that's not due process to the victims of crime, many of whom feel very differently than some of the people who have spoken here today, because those are the people I talk to every day. Those are the people I represent every day. And it would never end. And so it's more about the process than the standard of proof. And what is often left out in the arguments about how our standard of proof is too high is the whole process of seeking the death penalty to begin with. All the steps that are built in, the procedural steps that are built in to protect people when the state is seeking the death penalty. And I'm saying they need to be there. They must be there. We should be held to these high standards. And those processes are not only the trial process where the jury must decide unanimously. By the way, all 12 must agree that not only are they guilty, all 12 must agree that they're not intellectually disabled. And then when they go to the sentencing phase, all 12 must agree that they should be sentenced to death. If one person in the sentencing phase says, you know what, I see that the defendant in the guilt innocence phase, he claimed that he was intellectually disabled, and we don't agree that he met his burden of proof on that. So we found him guilty, but intellectually disabled. In the mitigation phase, in the sentencing phase, they can still argue, and they do argue, okay, you did not find that we met our burden of proof that he was intellectually disabled, but please do not sentence him to death because there is evidence that he's intellectually disabled or mentally ill or whatever else they want to argue. There's no burden of proof put upon them in the sentencing phase. They can say, you can, and our jurors are actually instructed, you can give the defendant a life sentence for any reason at all or no reason at all. You can just give them a life sentence because you feel like it. So in the mitigation phase, there's no burden of proof put upon them at all about proving whether someone is intellectually disabled or not. And even if the jury rejected it in the guilt innocence phase, they can still say, well, I'm going to spare his life anyway. And that is an option that they have. So we have that procedural, what's the word I'm looking for? Procedural built-in process there. Thank you, Representative Miller. And from there, it goes direct appeal to the Georgia Supreme Court because everyone convicted of murder, and including capital murder, goes directly to the Georgia Supreme Court for an appeal. And then from there, there's a state habeas. And from there, there's a federal habeas. And so these cases are litigated for a good 20, 25 years. The fact that nobody, essentially what they're telling you is because nobody has ever won, nobody has ever convinced a jury that they are intellectually disabled, our statute is flawed. And that logic is flawed. And the logic is flawed because what you don't see, and what many people don't see, are the cases that the state works out. The cases, and I can name a few, like Joseph Smith, who was facing the death penalty in Fulton County, who then we got a packet of information that let us know that he was in fact intellectually disabled, and we withdrew the notice of intent to seek the death penalty, and he pled to a life sentence. Those are the cases that people don't see. And what they're also not taking into account is the federal and state habeas. So there's a case, Eric Perkins, that was tried in Bartow County, where a 16-year-old was kidnapped and shot in the back of the head. That case, he was given the death penalty in 1998. He claimed to be intellectually disabled. The process went through what I just described to you. A jury rejected that, found him guilty, and then in the sentencing phase, sentenced him to death. He went to direct appeal to the Georgia Supreme Court, survived. Went through state habeas, the conviction survived. On federal habeas, a federal court found, well, he had ineffective assistance of counsel in the sentencing phase. Therefore, I want you to re-sentence him on whether he's intellectually disabled or not, and that's a trial that's currently pending. So I don't think that you can just point to something that has never happened to establish that the system is flawed. So having said all that, it's not the burden of proof that we're fussing with the current iteration of this statute before you. It is the intellectual disability applies to all felonies, not just capital murder. And we litigate it most in capital murder because you're not eligible for the death penalty if you are found to be intellectually disabled. But the way that the current statute is written on page 3, section 3, line 64, there's no mechanism for a jury to find someone guilty there. So presently, if you claim to be intellectually disabled, a jury can get 5 verdict forms or 5 verdict options: guilty, not guilty, guilty but mentally ill, guilty but with intellectual disability, or NGRI, not guilty by reason of insanity. The way that it's written, the way the word guilty was taken out there, if they find that the person meets the criteria for intellectual disability, and let's just say this is a regular murder, not even a death penalty murder, well, have they convicted them or not then? Because I'm not sure. I don't see where they allow them to be found guilty. So if that stands, then in a non-death penalty case and just a regular murder, which is still bad, a person could be acquitted in with a strange hiccup there with the way that it's written. And then most importantly, this new statute creates a quadricated process from the way that I'm reading it. And that means that if a person claims to be intellectually disabled, first a judge will get to decide whether they're intellectually disabled. And then if they lose with the judge, they get to litigate the exact same facts in front of a different fact finder, having lost before the judge. Then they get to litigate the same issue before a jury. And if the jury then finds that they're not intellectually disabled, I still don't see that in the way that the statute is written that they actually get to find that they're not intellectually disabled. They just find them guilty twice, which is unlike any other statute I've ever seen in our jurisprudence or the other states I've practiced law in. It also requires the jury to find the defendant guilty twice if he claims to be intellectually disabled. So there are some real problems with the procedure. But most importantly, it is the fact that if a judge finds, it literally is taking the decision out of the hands of the people. It's putting the decision in the judge. The state cannot appeal the judge's determination of whether this person is intellectually disabled, and we're done at that point. But if the state wins in front of the judge, well, we have to do it all over again, now in front of a different fact finder. And that is wasteful. It's not fair to the victims of crime. It would be very difficult for us, especially under our current condition. I don't know if y'all have read the ABA article that says that prosecution offices are anemic. There's 15% staffing shortages in all prosecution offices. So it would be very difficult for us to then litigate the same issue twice in front of now a different fact-finding body. And even when we litigate it the second time in front of a jury, it's now a trifurcated proceeding where it's guilt innocence, and then they determine whether they're intellectually disabled, and then we go to the mitigation phase of the trial. So I think that's about all I have as far as the iteration of the statute, if you all have any questions.
And the other thing that I can chime in and suggest that if you wanted to make this a simple bill and change the burden, which is an option, that's a policy decision that you, as the elected representatives, have the option to do. The only thing I would urge you is, number one, speak to our friends in the AG's office first to understand the consequences, because there is the potentiality that everyone who is currently on death row would immediately get a new appeal under the different standard. There's ways that we can you can write in the language and say they don't. I don't know if that passes constitutional muster, and that's outside my lane. But that's something I want to make sure you understand. That's a policy decision as to what the burden of proof is. I can, as Sheila has said, and as I will reiterate, the U.S. Constitution has said your current standard, they approve of it. We know that's safe. If you make a change to it, we don't know if it's safe or not. We don't know what landmine you might step on and how much litigation you may have to suddenly go through and what it will do to our process. We don't know that.
Thank you. Representative Miller?
Thank you for your presentation and for being here and for being you, my friend.
I just know what you're capable of. Don't ask me a question. I never want to answer your question.
No, I do just want to explore some of the things
Okay.
that you addressed. So if a judge has the ability, sort of the first of the, I think you said trifurcation, where the judge has the opportunity to, this is in death penalty cases only, right?
That is my current reading of it, yes, because there seems to be a distinction made between capital and non-capital cases in 17-7-127, which is a new statute that would be built, yes.
Okay. So the state has introduced its notice of intent to seek death. The defense files some kind of notice saying that they believe the client is intellectually disabled. There is a hearing before the judge. The judge finds, at that hearing, the defense would have the burden by preponderance of the evidence under the statute, under what's proposed here. Just trying to make sure we're on the same page.
Go ahead.
The defense would then have the burden to establish by preponderance of the evidence that the accused is intellectually disabled. Yes?
Yes, although the language upon a joint motion of the defendant and the state, which is on page 2, subsection C, that language confuses me. I don't
Okay.
know if we have to agree
That's
to
fair.
that or not.
That's fair.
But maybe in theory, the answer to your question is yes, but some could argue, and I would actually argue, well, there needs to be a joint motion. What if we don't agree? Because, we frequently don't agree.
Frequently.
Right.
Okay.
So
well,
that needs to be cleared up.
I agree with you on that. I agree with you on that point. But let's assume, for the sake of this, because I just want to drill down on the procedural burden that that you're concerned with. So, judge has a hearing. Judge decides that the accused is intellectually disabled. It's your position that, and I guess this is what I'm trying to make clear, that under our current framework, including this bill, the state would not have the ability to appeal that
That's
to the
correct.
Supreme Court.
That's a final judgment.
Okay.
That's like when a judge finds the defendant has acted in self-defense and a pretrial immunity in a murder case.
Okay.
So it's a final judgment. So there would have to be you would have to give us a special grant, and you would have to give us permission statutorily to appeal that.
Okay. So then what is sort of the difference between this sort of procedural hurdle in this case and, say, when we have a person that is not competent? Can you just talk me through that?
Because you have the right to a jury trial and a competence proceeding if you so choose. So the difference is that you're letting one person, a superior court judge, make a decision for the community. You're taking it out of the hands of the people. You're taking it out of the hands of the jury on something so important to the community. That's the difference.
Okay.
All right. And so
Without the right to appeal it.
Okay. So then if there were a procedural safeguard inserted in there that would give the state the right to appeal it, because it would seem to me that if we're going to make this finding, the sooner we make this finding in the process, the better it is economically for judicial resources and all of that stuff.
Agreed. That's why we have discretion to plea them, and that's what we do. So what you are talking about is a procedure where we are entrenched, and you're a litigator, so I know you know what I'm talking about, which is why you're nodding your head, where we're entrenched, where the defendant says, I'm intellectually disabled, and the state says, oh, no, you're not. And so we're talking about, in that small class of people, in the cases where we haven't been able to work it out, who gets to decide?
Right. Somebody
and the
has
state
to.
wants the jury to decide.
Understood. Now, if we were, I'm sorry, Madam Chair, just let me finish this train of thought. I know we don't have all day. And I think I lost my thought. Come back to me.
Yes,
One of the other
we
points
have one more question.
If I may, one of the other points to point out is that as Ms. Ross has been saying about jurors, we qualify. Both the defense and the state have a right to ask questions of the jurors before they're selected. Neither has a chance to ask questions of the judge.
Okay, go ahead.
I'm actually going to go to Chairman Smith. Chairman Smith.
Okay, thank you for being here. Appreciate it very much. So you think that we could achieve what the intent behind this legislation would purport to do if we just made a simple change to the burden and already pre-existing procedures here, correct?
Yes.
Okay. And so we wouldn't need the rest of the, which language would we have to eliminate from this, or just do a total rewrite of the bill? What would be your suggested change?
Well, I would have to get it for you. It is the part of the statute under 17.7.131. It might be in J. It might be in C. I have it in the current statute. Hold on just a second.
Okay.
It's hard for me to read the other one.
Take your time, I've got all day.
Okay. If you go to the current statute, 17.7.131, C3. In C3, it says, a defendant may be found guilty but with intellectually disabled if a jury, and that's where we're at, or the jury, or court acting as trier of facts, because the state can consent to a bench trial on the issue. That's not what we're talking about here. But we presently can permit a judge to do it. Finds beyond a reasonable doubt that the defendant is guilty of the crime charged and is with intellectually disability. So if you simply substitute in, and I'm not a legislative writer, I'm a trial lawyer, so y'all, you probably a better question for Roberts. This is my trial lawyer opinion. Subsection C3 of the current statute, fines beyond a reasonable doubt should be fines by a preponderance of the evidence. To me, that seems the simplest way to change it.
That's line 122 of your current version of the bill.
So if you want to change the burden of proof, which I don't think really anyone opposes, for the defendant to have the burden by preponderance of the evidence, by my estimation, that would be the cleanest and easiest way to do it. That doesn't erase the concerns that Mr. Smith already spoke of with the Attorney General's office, but that is to answer your question.
So we still need to have their input. Right now, as it stands, would you contend that this process and going through evidentiary hearing on this, it's a battle of the experts from the state and the defense?
It can be, but it isn't always. We retain experts and the defense retains experts in that rare situation where we're entrenched, like I just discussed with Representative Miller, where the defendant claims he's intellectually disabled and we say, no, you're not. We've looked at all the evidence. Everybody does retain experts. Sometimes they call their experts, sometimes they don't, because sometimes even the defense expert will say, well, I don't think he is intellectually disabled, so then we never see those people. So it is a battle of the experts, but it isn't always a battle of the experts. A lot of times it's school records. It's also testimony from lay witnesses, people who worked with the individual, people who raised the individual, teachers. I know the last trial they had, which was in Wright-Barksdale Circuit, they had teachers come and testify that the defendant was intellectually disabled, that in 5th grade, 7th grade, 11th grade, they were intellectually disabled. And that evidence is put before a jury. So it isn't like the defense is being hamstrung in what they can present, because they can present anything they want to present. We're just talking about mainly who gets to make the decision in this new suggested statute.
So right now, I appreciate you clarifying on that and who can testify to this. We could still have the same situation in front of a judge under this new structure that this bill would provide.
It would be in front of a judge, and the way it is that the judge gets to decide first, and only the judge. And if the judge agrees with the defendant, then they win, it's over, we can't appeal. If the judge doesn't agree with the defendant, and he in fact agrees with the state, we got to litigate it all over again. The same issue, the same facts, with a different fact finder.
It's just, my worry is, I haven't experienced some of this with expert testimony or anybody's testimony. My concern is this: judges seem to be just as susceptible, if not more so, than sometimes the jury in these determinations or weighing the expert's testimony. And so, I mean, this going before, I mean, our experience, and I would ask you to kind of weigh in on this, jury gets it right 9 times out of 10. And so it sounds as if we have knowledgeable enough juries that can decipher this information. And so and I'm sorry, I'm kind of compound questioning here. So if I get a judge that has been a former prosecutor, I may get a certain inclination one way. And if I have a judge that's a former defense lawyer, I may get a determination the other way. And is that some of what the concern is here too?
Well, that's not my personal concern. My concern is taking it from the will of the people. I am a litigator. I have litigated my whole career. I've been a litigator in Florida and in California, but mostly here in Georgia, and I believe in juries, and I believe in the jury system. And so I don't ever want to see a bill where the decision is taken from the people.
And Chairman, to answer your question from a different perspective, one of the things when you have a jury, you have 12 people that can lean on each other. They can lean on their common experiences, their common understanding of things, their views, and be able to discuss that back and forth. A judge, is a single solitary man or woman. They have no one to lean on but themselves. And as you said, they also have their implicit biases. We can weed through that process the voir dire process when we ask jurors questions. That's part of our purpose, is to ask them to understand and try to put together a jury that represents a community, but also we can be able to speak to. With judges, is it fair for a defendant to be have this kind of decision made by the former DA and our governor, the previous governor, and the governor before him have all seemed to prefer to enjoy putting DAs on the bench, but they also have put up defense attorneys. They've also put up civil litigators who've never spent a moment in a criminal case. That's not saying they can't do the job, but just as you would not want to be here because only one person voted for you, you want to have your communities voting for you. You want the majority. We're asking for the unanimous decision of the community to make such an impactful decision. This is not something we do lightly. This is the ultimate sanction. This is the ultimate expression of will by the community about conduct, holding someone accountable for what they did. Do we really want this to be left on the shoulders of one person? Should not the entire community have a voice in this? That's one of the comments we hear about "not in my name," as the protesters exclaim about when these sentences carried out. Shouldn't they have a voice in this process?
And I do think, speaking of victims of crime quite frequently, which is what I do day in and day out, it's important for them to feel good about the process as well. They don't choose to be here. That case I told you about, she didn't choose to have her son executed when he was 16. They feel better about the process if the community speaks. They may not agree, and I've had verdicts that I don't agree with the jury, but I agreed with the process, and I can't fault them for it. Victims feel better when it's not just a judge making a decision. It's the process, it's the jury, it's the will of the community. When judges make decisions that victims' families don't like, they automatically assume they're paid off or they're not, they're biased, and it's not true. It's not true. We got great judges in this state. It's just people feel better about the process when it's made by the community.
Thank you.
Chairman Leverett.
Thank you, Madam Chairman. Thank you all for your testimony today. I wanted to explore something. As I've disclaimed before in this committee, I do not practice criminal law, so the sum total of my criminal advice can be summed up in a Willie Nelson lyric, which I won't repeat because I've done it before in this committee. But I gather your concern is one that this bill proposes to, at least in one instance, provide that a judge could make a determination that, if favorable to the defendant, would be binding upon the prosecution. Prosecution doesn't get any additional bites at the apple and can't appeal that, apparently. Two, you have concerns about allowing judges to make that determination as opposed to having a jury make that determination. Is that?
Yes.
Yeah, okay, so we're going, and then I think there was also just a concern, and I sort of stated this in the first one, but you're not only having the judge make that determination in the first instance, the defendant can continue to raise that issue and relitigate that issue all the way throughout trial.
Not only throughout trial, but then again in mitigation, then again on state habeas, then again on federal habeas, yes.
Okay, all right. So are there instances in which, I know in a criminal case, judges do make determinations with regard to seizures and certain Fourth Amendment violations, admissibility of evidence, exclusion of evidence. I understand this is a little different because it sort of goes to the state of mind of the defendant. Is there a current procedure that would allow for a trial just on that issue before you do guilt and innocence? Because I gather one of the objections the people that sponsor the bill are concerned about is guilt and innocence and disability are all rolled into one trial at one time at the end.
But it's all rolled into one trial during the guilt innocence phase, yes, because there is still yet another trial if they're not found to be intellectually disabled that they have after that. But to answer your question, I think Representative Miller, with her vast experience, was spot on. The only representative of that I would know in our current statutory scheme would be where someone claims that they are not competent to proceed for trial. So in present-day jurisprudence in Georgia, and it happens frequently in murder cases, I've had to try them, a defendant will claim that they're not competent to stand trial. The state has the right to a jury trial on that issue. And so I'd had a case where we had a competency trial, and it's a different jury. They're selected, and they say, I'm not competent for trial. The jury finds them to be either competent or incompetent. If they're found competent, then we go on with our regular litigation. So there is something in that you can look to that shows to have a separate proceeding, and it is there in our competency trial, which is why Representative Miller mentioned it. She's spot on, it's there. But the difference between that and this statute is that a jury decides. The state has the right to a jury trial in a competency proceeding.
So the question I was posing is, and this is something you may need to think on, is what would your position, I don't even know if this is something anybody's interested in, but would a possible alternative or an acceptable alternative be to provide a statutory framework for a jury trial on that issue if the defendant raises it properly, and have that jury trial decide the issue so that it couldn't continue to be raised? Because I'm assuming all this is statutory structured.
So what you'd essentially be proposing is after a judge's finding, there's the initial gatekeeper.
No, I wouldn't have the judge be the gatekeeper. It'd be an issue that would be raised, and then that would go to a jury trial on that issue, I'm assuming.
So you'd have so basically kind of like competency, you'd have two different juries involved in the process.
Yes, that's what he's suggesting. But then frequently intellectual disability and competency are raised together. So frequently,
you try them simultaneously by one jury?
Well, currently we cannot. But if you were to propose this, then what we could potentially have is basically 4 trials: a competency trial with one jury, then a different trial of intellectual disability with now a second jury, and then after we do all that, if we win along the way, now we've got a third death penalty trial, and again that gets into that's now 3 different juries for essentially the same issue. And again, let's just say you had that structure.
Well, no, they're different. 2 of them are very related issues, correct? Competency to stand trial and intellectual disability might have some similar elements.
Yeah, but presently they're very different issues. But yes, people will say I'm not competent to proceed because I am intellectually disabled. But you don't have to have a finding of fact of whether they're in fact intellectually disabled. You just have to have a finding of fact that they're competent to proceed, which is a different standard. But you've given us something to think about. No one has ever put it that way.
I don't know enough to ask you intelligent
yes,
questions that are finite.
Yes, that was
it's a
great.
Continue to take more time, but that was just that.
Yeah.
I understand your objections. I don't particularly like the fact that as drafted, it would appear to me that the defendant gets to raise it even after he loses it at one point. And there may be some policy reason or constitutional reason to do that I'm just not aware of, so other people can address that. But that was just a concern I had. But I sort of share your concern about, is it best to have judges make that sort of determination? But I also wonder, is it best to wrap all that up into I guess what is essentially a guilt and innocent phase by a jury? Because if we determine that early on, that probably might end up having the case resolved at an earlier stage. So anyway, I'm sorry, I'm engaging in a lengthy conversation at everyone else's cost right now.
No, that was something that has never been put to me that way, and I guess it's something for us to think about, so thank you.
From the mouths of babes, as they say.
Real quick, pass this bill. Let's say that this was enacted today or tomorrow. How many individuals on death row have attempted to raise this issue of being mentally incompetent to stand in a death penalty case? How many are on death row right now that have tried it in the past and that I would assume would probably file new challenges should this statute pass?
Well, I know that they have 40 total right now, but I don't know how many have claimed it. Yeah, that's litigation that is handled exclusively by the Office of the Attorney General of the state of Georgia. I know that we presently have 40 people on death row. I don't know how many of them claimed intellectual disability at the trial level, because remember, our statute's been around for a very long time. Our statute's been around since 1988. We beat the Supreme Court. So many of the people on death row had the opportunity to litigate this in 1988, but only the AG's office can answer that question.
Okay. Sounds like we need to hear from them. Representative Miller.
Really quick, and actually Chairman Leverett raised exactly what I was going to say. I turned my light off, but then I wanted to follow up. So if there were to be a competency-styled proceeding that would allow a defendant to raise separately from guilt innocence his intellectual disability, that sounds like that would alleviate at least some of the state's concerns as it relates to having a judge be the only person to decide this. I know you have to think through it, but I'm just saying.
Well, I don't think through that. The answer is yes. Of course, it would alleviate our concerns. Now, it doesn't mean we would like the statute. We'd have to see it.
I understand.
And see how it works out.
I understand.
With the other statutes that are already out there.
And then you said 4 juries. So if there is a competency-style jury who would take a first crack at it, then there's guilt innocence. The same jury that decides guilt innocence would decide sentencing, correct?
Right, but I said 3 juries because if competency and ID or intellectual disability are raised together or concurrently, it would be a competency trial the way our current statute is, a competency trial. Then you want to do a separate trial for intellectual disability. This would be a new statute. No. So that would be then an ID trial, and then there would be a guilt innocence trial with a mitigation trial, but the same jury, so that's 3 juries.
I got you. That's where I was confused. So
okay.
When I say competency, let me stop saying competency. Let me say if there was a mechanism for an accused person to file a notice and raise intellectual disability. Mm-hmm. And then within that framework, there was the option for the state to request a jury trial or to proceed with a judge doing it, but you have the option to request a jury that decides just that issue. Okay. And then let's say the accused gets an unfavorable decision from the jury. He moves on to guilt innocence. He then gets to argue guilt innocence and again argue intellectual disability in the context of the guilt innocence phase of the trial, but it's 1 jury.
I think it would depend on how you rewrite 177131, because what would happen, the way that 177131 is presently written, it would be an ID trial, this new procedure, and then we go down to 177131, and it's ID and guilt innocence all over again. You're saying get rid of that, right? You're moving it out. I'm trying to follow along. Yes.
Yeah.
Okay, so you're moving it out, and so jury number 1 is intellectual disability. If the state loses, we're done anyway. Jury number 2 then would be the death qualified jury to decide guilt innocence and mitigation.
Okay.
And so that would be 2 different juries. And then it would be guilt innocence. Are they permitted to raise ID and guilt innocence under this new statutory scheme or not?
I mean, I would say probably, and the reason why I'm thinking about it kind of like self-defense, although it's a separate issue, but the framework is the same. The defendant can raise self-defense pre-trial. He can get a ruling that's adverse in the pre-trial motion, and he can still argue that again in guilt innocence.
Okay, so then under this new statute, we would have to convince 24 people, not just 12. Or this new statutory scheme that you're suggesting. I would have to see it to think it out. If you want to, really want to talk about it all day, we could.
I think that makes sense.
I think what you just told me then is we're litigating it now twice with 24 people, not 12.
Mm-hmm. But you said 3 juries, which would have been 36.
That's because I was considering competency, ID, and then.
I see.
That's why.
Understood.
I took your idea, and then he took your idea and then took it a different level, and I took yours combined.
Okay.
So I was in that world of 3.
Copy.
This would be 2.
Copy.
So just for the non-attorney members of the committee, if y'all could just walk them through as far as how many juries are involved in the current process?
In the current process, 1. One jury.
They determine, so in other words, they determine both guilt or innocence and then headed on to the sentencing phase as to whether death should be the punishment.
Right. They consider in the guilt innocence phase whether the defendant is intellectually disabled or not, whether he's guilty, whether he's not guilty, or whether he's guilty with intellectual disability. If they find that he is just guilty, then they go on to the mitigation phase, this same jury, and they decide what the proper punishment should be. And in the mitigation phase, they can still consider his intellectual disability or claim of intellectual disability as a reason not to give him the death penalty.
So in all fairness, from a defense standpoint, I get basically 2 other shots at this. No, under this current structure. Is that a concern?
Under this current bill, yes, that's part of our concerns.
Okay. Just putting that out there. So we would be going from 1 jury to
At least 2.
at least 2.
And something that I just scribbled out to Ms. Ross, if you have never had the pleasure or pain of going through this process to pick a jury, you do not pick these juries in one day. The jury selection process takes weeks, and it doesn't matter if you're down the street in the Atlanta Judicial Circuit or if you're in a much more rural circuit where you've summoned in hundreds of constituents to sit and be called in day after day. So if you want to have a second juror, if you want to have a third jury, you now are going to be essentially doing jury selection for months or weeks, which is due process that is fair. And I'm not advocating for one way or the other. I'm just simply saying, understand what we're getting ourselves into. Because the other thing too is when you bring each one of those jurors in, the county pays them by the day.
Representative Miller.
But just because I don't want to confuse the issue. It takes a long time to pick a jury who is deciding death, okay, as it should. But if you have, say, a competency trial where we're not talking about guilt or innocence, we're just deciding the narrow issue of intellectual disability or whatever the case may be, it's not going to take us weeks to get a jury to decide intellectual disability. I mean, I agree with Madam DA that, juries are great, right? And that's our system. But I think let's not confuse the issue. This would not be a month-long jury selection process if we were carving out just the issue of intellectual disability. And I do think what has not been addressed is effectively, in my opinion, is the point raised by Chairman Leverett, and that is when you start to mix guilt innocence, which can be very inflammatory, which is in part why I think you read the version of the facts of this person, because when you hear what a person did, it becomes more challenging to decide in an unbiased and fair way whether or not that person is actually intellectually disabled. And so that is the concern, I think, that is driving this bus. And so my hope is that we can make this a lot simpler and we can take into account what I think is a real concern. We're the only, well, that's not true. That deals with something else, withdrawn. But I think that's just, I just wanted to make that point and be clear on that.
It would be great if we could do that and not have a discussion about the facts of the case and look solely at the intellectual disability of the defendant. I'm not sure it's possible or fair for the defense to tie their hands that way.
Well, and I would have to say that Moore v. Texas and some of the litigation on intellectual disability, that you cannot, when litigating these cases, one cannot exclude the possibility that a person who is claiming to be disabled might be malingering. And one of the motives for malingering is facing the death penalty. So when the court had structured, because of our statute was in 1988, there were people who were convicted and put on death row pre-1988. When those people, after the statute changed, then filed motions to have their intellectual disability litigated by a jury, the court put in play a position or a procedure in determining intellectual disability under those circumstances. And in that case, those juries are death qualified because of what I just said to you about the the malingering and the fact that the experts, when they interview the defendant, they all have to test for malingering. And so that those facts do get put before a jury, maybe not the exact facts of what they did, but it is a motive for malingering, which experts do consider. And it is the experts that will determine whether someone is, in fact, meets the criteria of intellectual disability under the DSM-5. So, again, all things that you've given us good things to think about. I would just have to see what y'all put in writing, and we can talk more if you wish to, or if you don't wish to. Thank you.
Another question, and great discussion by members of the committee. I want to thank y'all. We all knew coming into this that this was going to be a very, very serious topic. My question is this. The way the bill's currently written, as you have read it, and the best that you can opine, would you say that someone suffering from ADD, ADHD could claim this to avoid being executed?
I think by the face of the statute, they would have to file something that says that they are, in fact, intellectually disabled. And I would have to defer to an expert on whether they think or whether they believe that ADHD would then allow this person to meet the criteria under the DSM-5 for an intellectual disability. The main concern I have with it is if you claim intellectual disability in a non-capital murder, that means just any other murder. Right now, there's no current mechanism for you to be found guilty. So the first thing I would do is if I were charged with murder right now with this statute and no one sought the death penalty against me, I would claim that to not be found guilty at all. So that's something that needs to be fixed for sure.
Okay, I'm sitting here thinking, and we all have individuals such as this back home, but I'm just sitting there thinking about the individual who had a developmental disability, and they're still able to obtain a driver's license. They're still able to maintain a minimum wage job, maybe sweeping the floor, stocking shelves, what have you, but whatever that developmental disability is, they're not going to be able to run the cash register at that store that they're working at. But yet, they can drive to and from work. They can buy alcohol, tobacco products. I mean, you name it. And so my question is, what about that individual? I mean, argument that, everybody gets a driver's license, we just throw them out the door a lot of times, but it's not as hard to get a license anymore. But I mean, that's a scenario I'm thinking about. One of these individuals back home. That's who my mind goes to in this scenario. I mean, what about that individual?
Well, even under our present statutory scheme, no changes made at all. That person can claim they're intellectually disabled if they're charged with a capital felony and the state files a notice, and that will be litigated by a jury of his peers. So they can claim it. They can claim it now. They could claim it under the new one. That is the way our law works.
Okay. Number 16, is that Chairman Leverett?
Yes, sir. Yes, sir. Thank you, Mr. Chairman. Just trying to sort of get my legs under me on the topic here. It looks like the proposed bill would not change the definition of intellectual disability. It utilizes the current definition that's in 177131. So that I don't know exactly what that means. I don't know how it works in real life, but that doesn't seem to be changed at all. So I don't think the bill proposes to change that definition or that legal standard. What it does propose, of course, is to not only change the current burden of proof, but it would also does seem to the point that's being made by the witness, it somewhat extremely changes the current process by which that issue would be raised and the means in which it's decided, and it allows the defendant to continue to raise it at various times, even when they've had an adverse determination as to that issue. So I guess it also does change what are the current permissible findings in the guilt or innocence phase, so that guilt but with intellectual disability is eliminated, and now it's just meeting the criteria. And I'm not really sure what would the consequence be in a criminal trial if you take away that particular finding of guilty but with intellectual disability and replace it with just, well, we find that he's got an intellectual disability, does that mean, I mean, to your point,
It has no legal significance.
it doesn't seem to involve a finding as to guilt or innocence. And maybe there's a reason for that. I just don't understand it yet.
That could be used for any felony in this state.
Well, Mr. Chairman, I do read the statute as limiting some of these procedures to capital cases.
Right, but the procedure that you just discussed about the 5 jury verdict options, that means you can raise in the current statute and in this proposed statute, a person is permitted to raise the defense of intellectual disability for any felony. But if it's a capital case, a death penalty case, then they go under this new subsection of 17.7, 127, which you expertly summarized much better than I did. Okay, so it would be an option for any felony in this state, the option of no real verdict. I mean, that's no real verdict. I would claim then on appeal that you are stopped from trying me again because I've been acquitted. It's double jeopardy because that has no legal significance with intellectual disability.
So I gather 17.7.131 is not just a capital, it's a general sort of state of mind, intellectual impairment statute.
That's correct. It is
criminal liability for conduct.
It is the statutory procedure that we follow for guilty, not guilty by reason of insanity, and for guilty but mentally ill, and for guilty but with intellectual disability. It covers all of those things.
So, back to my point from earlier, if we made the change in line 122 that y'all had suggested, of course I know we're talking, this is a discussion here. We make that change, that wouldn't necessarily run us afoul of every other criminal statute being an issue here as far as someone trying to take advantage of these changes outside the scope of the death penalty, if we made the change as discussed in line 122 of the bill.
I defer to Mr. Smith on that.
The change being reducing the standard?
And doing that only, not the rest of the bill. Let's just about the hypothetical change that y'all posited earlier.
I would want to phone a friend before I said yes or no.
Sure.
Because, as we said before, those folks in the law department are the experts, and they would know about retroactivity and the application of due process here, because I don't.
Okay, all right. Thank y'all. I don't see any other questions. Have one last speaker. Is that the Southern Center for Human Rights? Mike, good to see you again. I know I just read your name out loud, but if you just say for the record your name and who you're with.
Good afternoon. Thank you, Chairman Smith, Chairwoman Young, members of the committee. My name is Mike Adbrand. I'm a senior attorney in the Capital Litigation Unit at the Southern Center for Human Rights here in Atlanta. My colleague, Patrick Mulvaney, who is the managing attorney of the unit, is with me, and I see Maisie Lynn Gerton from Gactel has also joined. I'm going to try to be brief. I have a couple of big picture responses to what you've heard this afternoon, and then some more technical ones on the bill itself and the proposed procedure that I'd like to address. The first is you heard Ms. Ross say that Georgia was the first state in the country to exempt intellectually disabled people from execution, and that is true, and we deserve a lot of credit for it. But we should also take something from the fact that every single state in the country looked to what Georgia did and chose a completely different option. And they chose a different option in two ways. First, no state decided to set the standard at beyond a reasonable doubt. And second, no state asked a jury to decide at the same time that they were deciding guilt that a person was also intellectually disabled. So we have an outlier process. And if you look to what the U.S. Supreme Court has done when other states have outlier processes, I think we can see what's coming down the pike here in Georgia unless there's a change. Florida had an outlier process where they used a strict cutoff. You had to have an IQ of 75 to even make a claim. And the U.S. Supreme Court upheld that statute for years and years and years until they finally stepped in and decided after years of challenges to invalidate it. Louisiana had its, and I used to practice in Louisiana, Louisiana had an outlier process where there was a pretty high threshold to even present evidence of someone's intellectual disability. It was challenged for years and years and years, upheld, until finally in 2015 the U.S. Supreme Court stepped in and decided to do something about it. More recently in 2017, Texas's procedure, which used the novel of Mice and Men to inform its process for intellectual disability claims, that had been challenged since the day Atkins was decided in 2002. 15 years go by of the U.S. Supreme Court upholding it until they decide, actually, no, that's not acceptable. Georgia, the same thing has happened here. Yes, the statute's been challenged time and time again, and it will continue to be challenged time and time again unless and until the legislature changes it. And even members of the Georgia Supreme Court, other federal courts, have urged this body to do something to finally step in so that the U.S. Supreme Court doesn't have to. The second point I'd like to make is, Ms. Ross mentioned that just one person over the last 35 years of Georgia statute, 38 years rather, has been found intellectually disabled by a jury. And she suggests that that's not evidence that it's unconstitutional, just that it's rare. She also said, what that number doesn't capture is all the cases where we agree. The parties come together and agree that someone's intellectually disabled. But she also said that frequently the state and defense don't agree. And the whole point of Atkins is that the Constitution protects more than just the people that the state thinks it should protect. There are going to be cases at the margins where we have compelling evidence of intellectual disability, but it's impossible to meet a standard beyond a reasonable doubt. Medical experts have said that they don't meet that standard beyond a reasonable doubt because you can't do that scientifically. There's no other place in Georgia law that requires someone to prove their intellectual disability beyond a reasonable doubt. It is just this specific process. The third point is regarding the current cases, the Attorney General's involvement, and of course you should consult the Attorney General. But what this bill does, this bill says nothing about people who are currently on death row. When I was here a couple of years ago, and I checked my memory, but I believe the number that we verified was 4 people on Georgia's death row out of 40 had raised claims of intellectual disability. This bill says nothing about those people. This is purely about people who are currently facing trial and facing capital prosecution, not about the people who are currently on death row, and it does nothing to change the definition of intellectual disability. Regarding some of the specific concerns with the legislation that came up, the first is the pretrial hearing and taking the decision out of the hands of the jury in their formulation. A couple of points. One is that under this version, that hearing is optional. A defense can file a motion for a pretrial determination before a judge, and the judge can deny it. The only time a pretrial hearing is ever required under this proposed legislation is if the two sides agree that a pretrial determination should happen. So, if the judge has a hearing and denies the intellectual disability claim, it'll still be in the hands of the jury just as well. Or if the judge just denies the motion altogether, it'll still go to the jury. The second point regarding the state's right to appeal, I will say that on lines 208 and 209 of the proposed legislation, there's inserted in there specific language authorizing the right to appeal pretrial a determination of intellectual disability. And the purpose of that was intended to give both sides, including the state, the right to appeal. Before the hearing started, they said that we would have to put that grant in a different statutory section. There's no objection to that. That's an easy change to make. We were trying to give both sides the right to appeal. I also want to emphasize that there are, from the defense perspective, no new appeals authorized in this legislation. Every appeal, including the one I was just talking about, already occurs. The only new appeal that would happen if this legislation were adopted is that the state would get a new right to appeal an adverse intellectual disability determination. And then the final change regarded the verdict, which on lines 64 and 65, some concerns that takes out a guilty but intellectual disability verdict. That could just be sloppy drafting. I don't know any judge who would instruct that a guilty finding is not required, but be that as it may, that's an easy concern to hash out and not one that should hold up the broader picture of the bill. I'll be happy to answer questions. I don't know if my colleagues here have other remarks.
Do you want to speak?
No, just wanted to be right.
Just very briefly,
Sure.
I would second what Mr. Admiran said, and also just want to comment on just how problematic it is to have the determination of intellectual disability made in the very same exact phase of the trial as guilt in a murder case. Under the current standard, under the current verdicts, the verdicts read as guilty but intellectually disabled. And as Representative Miller was saying earlier, that the fusion of those issues and trying to, instead of just asking the jury the factual question about whether the person is intellectually disabled separately from the factual question of whether the person is guilty beyond reasonable doubt of the offense. Those determinations should be made separately, and one of the reasons, one of the possible explanations for why no one is ever able to meet this standard over 30 plus years in Georgia, even though we see in other states that have different procedures that people do meet the standard. It doesn't happen all the time, but people do meet the standards under these different processes that all the other states have. One reason for that is that the jury is being thrown the facts of the crime and the facts of intellectual disability together and asked to render a verdict. And often what happens is then they render a guilty verdict. But what can be lost sight of there is that how important that intellectual disability determination is. And so separating those out, I think, is just really important. So I just wanted to emphasize that.
Okay, thank you. Any questions? Representative Miller?
Can you speak to, thank you for coming down and for your testimony. Can you speak to this notion that this is not a determination that should be made by a judge, but instead should be made by a jury, even if that proceeding is somehow separated from guilt, innocence, one. And then two, I wonder if the rationale for having this decided, the opportunity for this to be decided by a judge is related to this question of when you mix in the facts of the crime and guilt, innocence with the determination about intellectual disability, there might be inherent biases that creep up that cloud your ability as a layperson juror to distinguish, whereas a judge might be better capable and better suited to make that determination without regard for the facts. So just kind of talk us through how y'all got to that point.
As far as the overarching question of who should decide, the judge or the jury, that's a policy question. There are benefits to either side on that front, and states have divided along the way. You'd be on safe ground regardless of what hand you put it in. By giving the judge the option for a pretrial hearing, I think it's much the same as, I know self-defense was brought up as another example, that sometimes a judge is more able to make some discerning judgments and strictly apply the law, put some of the facts of the crime aside, and just focus narrowly on the question of whether there's intellectual disability that sometimes a layperson has a more difficult time making. But you would be on sound footing in either way. And I don't think our allies have taken a strong position one way or the other.
Could I possibly use this one just?
That's, yeah. What number is that? 18?
One other point around jury determinations in this death penalty context that I will admit I was in juvenile justice for the very beginning, and I'm sorry if I've missed this being said, but I didn't hear it earlier. What I did hear, though, was this idea that the community needs to have a voice in this process, including the people who come to Jackson with "not in my name" proclamations on the days of executions. What you need to know is that anyone who has a principled stand against the death penalty will not be allowed onto any of the current juries making these determinations in death cases. So the idea that the entire community is getting some kind of a say is a fiction because of some safeguards that have been set up to determine how those juries are constituted. Again, this new idea that's come up today around whether or not we would be better off having a jury determination of intellectual disability prior to the case, like as the competency framework would allow. If that jury could be an ordinary jury, which I think it could be, because you would only be addressing that one issue of intellectual disability, you wouldn't need the death qualified jury in that case. That actually would potentially expand the ability for the true community to make these decisions. But I just wanted to raise that consideration for you, that when we've talked a lot about juries today, but this point around what a death penalty jury is, it's unique and different to any other jury in any other case. And there are people who are excluded from it, per se.
If I could just add one last remark on that. This current bill assumes that juries would make the decision except in the rare case where a judge determines pre-trial that someone's intellectually disabled and that finding is upheld on appeal. It's going to be a pretty small subset of cases. I've been doing this for almost 15 years. I think I've raised an Atkins claim in 2 cases. Maybe I'm just not a very good lawyer, but I think what it really means is that this affects a pretty small number of cases of people facing the death penalty. And the jury under this version and under current law is going to be the ones who make the decision.
All right, Chairman Leverett.
Thank you, Madam Chairman, and thank you all for y'all's testimony today. So just again, all I know about criminal procedure and death penalty cases is what I've read in this bill. It looks like there's a number of different determinations that can be made, I think, across the board, because I believe 17-7-131 is not a capital. It's not just a capital criminal procedure statute. So you've got guilty, not guilty by reason of insanity at the time of the crime, guilty but mentally ill at the time of the crime, and then currently guilty but with intellectual disability. And and then we've also talked about competence to stand trial, which my understanding is that deals with your state of mind right now at the time of the trial. All these others deal with your state of mind at the time the alleged crime occurred. So they're different points in time, but I would think those issues would still be somewhat related, so that a trial involving those issues would not be too unwieldy, it would seem to me. But with respect to sort of the issue of raising your state of mind, or a defendant raising its state of mind, which I'm assuming has consequences with respect to the kind of punishment that can be meted out.
No, sir.
It doesn't. So if I raise a defense.
Only intellectual disability would prevent execution, but
Okay.
otherwise, no matter which of these guilty findings were made, you would still be subject to the potential of life without parole on a murder case in Georgia.
Okay.
The only thing that these subsets of mental illness and insanity are meant to do is access to resources in the correctional context, which is a discussion for another day. But
Okay.
it doesn't actually do anything to mitigate your sentencing exposure at all.
Well, it does in a capital case, doesn't it?
In a capital case, intellectual disability is the only one of these frames that would prevent you from being executed.
So the others wouldn't necessarily take that off the table.
They would never.
But they are arguable to a jury in the sentencing phase of the trial.
Yes.
You can continue to argue, okay.
Yes.
So, I guess, you addressed this, I think, or I thought you maybe were addressing it, where there was some discussion of, we're sort of changing some of the findings that can be made, and one of them is no longer guilty, but with intellectual ability to just meets the criteria. Were you saying that is not necessarily a strong desire in this, that may have just been incidental drafting?
I don't share the same concerns that PAC has voiced here, but the broader point behind that change was just to separate intellectual disability findings from a guilty finding, and so whether we'd be happy to leave it as is, as current law exists, if that would mollify a concern, as long as the procedures outlined in other parts of the bill.
For me, it doesn't mollify a concern. I'm just trying to understand the distinction, because later on there is some of the language added said the jury may determine that the defendant meets the criteria for intellectual disability if the jury or court acting as trier of facts both convict the defendant beyond a reasonable doubt and find by preponderance of the evidence that the defendant has intellectual ability. Of course, here you're preserving raising the standard for intellectual disability, but this seems to contemplate that there would be a type of, I'm assuming guilt means you did it,
That's
but you were either insane at the time, or you were mentally ill at the time, or you had an intellectual disability at the time.
And so what that portion of the bill addresses, it would be that there's a process where the state and defense, if he chooses to, presents evidence regarding the alleged crime. If the jury finds that the person is guilty, they return that verdict, and then there's a separate presentation of evidence exclusively about intellectual disability.
Okay.
And then that's why we had changed the language to meets the criteria for intellectual disability, but if it would be the preference of the committee to have it guilty but intellectually disabled, as long as the presentation of evidence is distinct.
So currently, it's one jury, but are there two sort of separate phases of that trial in which they determine guilt or innocence, and then determine sort of mental state or mental capacity? Or is it all just done at one time?
Right now, it's one jury, and the guilt innocence determination is made at the exact same time the intellectual disability determination is made.
So the jury hears evidence on all those issues at one time, then they go deliberate and come back and enter findings on all of those things?
That's right.
Okay.
And the finding that they have rendered in every single case, except one over the last 40 years, is guilty. They never find guilty but intellectually disabled, and that's what our concerns are.
Is that the way it's also done with respect to other pleas that involve mental state, like insanity or mental illness?
Insanity is a little different, and that actually pertains to the time of the crime itself. Guilty but mental illness, it is structured the same way, where that finding is returned at once. And this has no changes to that procedure, and there's no constitutional protection for someone with mental illness. So the reason why we're trying to fashion a different process here is that the U.S. Supreme Court has made clear that the Constitution protects people with intellectual disability, and our current procedures aren't sufficiently protective.
Okay. All right. Thank you.
Thank you.
Representative Crowe.
Thank you. I just wanted to clarify amazingly what you were saying. So you're saying that if someone is currently, if they're found guilty but mentally ill or reason of insanity, they could still receive the death penalty?
Yes.
I didn't think that was the case. Okay.
I'm sorry. Mentally ill, not insanity. Not insanity.
Not insanity, but mentally ill
Mentally ill.
at the time of the crime, they could still receive the death penalty. Is that?
Yes.
Okay. All right. Thank you. I thought I'd heard something different
I'm sorry.
earlier, and I thought it was.
I may have misspoken by lumping them together. That's my fault.
Chairman Smith.
Thank you. I don't have a question for y'all. Brother Mike Griffin, I know you're just here observing. I know you didn't sign up. It's been since my freshman term, since I saw you with us. Thank you for being here. I know we heard from our friends at the Archdiocese and appreciate that perspective. Do the folks of one of the Reformed faiths have anything to say about this? Just want to make sure you didn't miss a sign-up sheet. All right, he passed. Thank you for being with us. We appreciate it.
Okay, great. That's all the questions that we have. Thank you. Sure, definitely.
Thank you.
Thank you. Chairman Werkheiser.
Thank you, and thanks for your endurance. And you asked me at the beginning if there was any opposition. I said I didn't know of any, so you put me first on the agenda. So I'm not an attorney, but I am very easy to find. So I'm a little disappointed that the Prosecuting Attorney Council didn't come with these concerns and these alternative fixes because they don't seem to be concerned with the actual what we're trying to do. For example, there was lots of discussion and looking up of cases that withstood the scrutiny of today's standard all the way up to Supreme Court, and it was said over and over that they withstood that. No one's arguing that. I'm glad that our laws are constitutional. So all I'm asking is that we change a current standard to a different standard, which would make it just as rock solid before the Supreme Court. So that's not even an argument. I would also disagree that in pretrial arguing the facts of the case without the criminal activity, that's the whole point. Because if you can't argue that someone is intellectually disabled except for the fact that they commit a crime, then I don't know that they are intellectually disabled, such as the case in 2015. It was very obvious the guy had been in special ed his entire life. And I will say, I don't want to put the words, in our Supreme Court, but two of those is very ironic that the Supreme Court was split on that. And when they both wrote the affirming and the dissent, there was some question about, not some question, it was they both made comments regarding the current law versus what the legislature should do. It was almost like they were asking us to change it. And again, I don't want to put words in their mouth. So, but I do think, and again, PAC's not arguing that we shouldn't change the standard. They may not like the language that was presented today, but again, we could have saved an hour and a half if someone comes talk to me. We could have moved that forward, and I look forward to that conversation. No one's asking that we make any of these cases retroactive. I don't think there's anything in this bill that does. In fact, that's pretty normal in law, that when we change law, we don't all of a sudden go back and look at everything that preceded that bill and then start changing things. And again, I'm a little confused about the phantom juries. We, thanks to Representative Miller, we did go from 3 to 2, and then with Gactel, I think we're back down to 1. I don't know where these other juries came from, but anyway, I am open to the two things that I would like to see. Again, we're an outlier. We're the only state that does beyond a reasonable doubt, and on something that is subjective. Well, the very definition of subjective versus objective is there is no concrete. So yes, you can raise a reasonable doubt. So all we're asking is, let's change it to preponderance of evidence, and let's get in line with the other 27 states that offer this. And we're the only state that doesn't separate pretrial determination of this without the facts of the case. That's the only two things I'm asking for. If we can do that in a totally different worded bill, I'm all for it. But that's what all I'm asking for.
Thank you, Chairman. And this is a heavy topic and a lot of opinions. I think we've at least come to a conclusion about the burden, and I think we can all agree on that. I think, especially with the members too, I think we'd like to kind of wrap our minds around it and work with, if you can talk with PAC as well, and if we can try to work on some of the language. I think we would like to see that, and if you can present that later on as well. So we appreciate your work on this, and we'll keep this a hearing only today.
Thank you very
Thank
much.
you.
Thank you, committee members.
let's take a 5 minute bathroom break. And then, and I know we're going to go ahead and hear 425 after the break. Thank you. All right, I think it's been 5 minutes. We're gonna go ahead and get started. Next bill is Representative Gullett's HB 425. And what number are you?
I just pressed it. Thank you, members of the committee, and Madam Chair. So this is a substitute. It's LC 481106S. And this bill is aimed at reforming our state's approach to the sex offender registry. And I would say a number of the recommendations are guided by SORB and GACTL. I think they would say a number of those things are from them as well. This legislation represents more than just a mere policy adjustment, though. It's an essential step towards enhancing public safety in our state. Primary goal is to protect the public, particularly vulnerable groups, from sexual offenses, which are not only heinous, but also leave lasting scars on victims and communities. Our neighboring states have implemented stringent measures for their sex offender registries, and I think that fact underscores the urgency for Georgia to bolster our laws to be ensured that we're in line with, if not exceeding, those regional standards. A couple of key aspects of this bill are age consideration. For individuals aged 80 and above who've completed their sentences, this bill proposes their removal from the registry. This approach is not a relaxation of vigilance, but an acknowledgement that the risk of reoffending at this age is significantly diminished. Interstate consistency, we aim to remove individuals from the registry who have been cleared in another state, ensuring our legal system doesn't penalize individuals twice and respects the decisions of other jurisdictions. And then thirdly, the bill introduces a 10-year minimum registration period for level 1 risk offenders, which to me balances the need for public safety with the opportunity for rehabilitation. And I think that by adopting these changes, we'll strive for a system that's fair, that's just, that maintains public safety. I just want to go over briefly just what some of the other states have as far as their minimums. Alabama, for instance, has a duration of the adult sex offender's life. You'll be on the registry. Florida is the duration of his or her life, unless you were a minor when you were convicted. And then it's a minimum of 25 years if you were a minor. Tennessee has a minimum of 10 years after termination of the sentence. South Carolina has a biannual registration that's for life. North Carolina has a 10-year minimum, with most being 30 years. California has a 10-year minimum for Tier 1 offenders following the completion of their sentence. New York has a 20-year minimum for for Tier 1 offenders, with life for Level 2 and 3 offenders. And if you look at today's actual bill, in Georgia, the original bill actually just changed an or from an and. We got a little bit more complicated with it because that's what we do sometimes around here. But and today it says 10 years have elapsed since the individual completed all prison, parole, supervised release, and probation for the offense which required blah, blah, blah. Or the individual has been classified by the board as a level 1 risk assessment, provided that the board has not done a risk assessment for the individual, court shall order one. So today we have an or. It's not even 10 years today. What we're trying to make is there a 10-year minimum for level 1. If you're level 2 or level 3, which I think there are very few of those, but those are the ones who rehabilitation is not likely. SORB has severe concerns. Then you would be on the registry for life. And so that's what we're trying to address. Happy to answer any questions. I know there'll be lots of conversation about it. And thank you.
Thank you, Representative. Any questions from members? I don't see any, and so we've got several people signed up, but Representative Kennard, I know you've been here several days. I will let you go first. And again, thank you for waiting and being here.
Sure. Thank you, Madam Chair and members of the committee. I think there's an acknowledgement that not all crimes are created equal, and neither are all sex crimes created equal. And that's why in all 50 states on the respective sexual offender registries, they all have a tiered system to assess the severity of the crime and the threat level. In Georgia, we have 3 tiers, as you know. Level 1 is the least severe of the crime and the least likely to reoffend. It's almost a microscopic number, like 3%. And most of those offenses were not with someone in the community, they were within the family of the offender. But when you look at a level 2 is actually more severe and a greater risk. And of course, the highest level is the sexually dangerous predator, high risk. But when you look at all the restrictions that we have on those on the registry, they're pretty uniform and it's one size fits all. For example, the distance restrictions we have on everybody on the registry, it's uniform from tier to tier. We have the 1,000-foot barrier as far as the proximity of where someone on the registry will work or live for schools, daycares, preschools, which makes sense, but also for houses of worship and churches. So what ends up happening is we have created some barriers for someone to work and for someone to live, even if they're a level 1 threat. So they can't live or work within proximity to schools and churches. So we are an outlier in this regard because 47 other states do not have any distance restrictions as it relates to houses of worship or churches. There are 2 other states, Arkansas and Montana, which do, but not on their lowest level tier. There's no restrictions for churches, but across the board in Georgia, it is. Which actually creates a public safety concern because if someone who is on the registry is not able to live or be employed, it creates homelessness. I see this every day in the program that I run. We can work with just about anybody, but we cannot work with someone who's on the registry who's homeless because we are a church. So I agree with some of the statements in 425. I disagree with the 10-year minimum because now on a level 1 person with all these restrictions, we have compounded their ability to get a job or have a place to live. We've doubled the length of time. It's going to create some unnecessary, I think, even public safety concerns. In Georgia, we're in the Bible Belt. In Georgia, we love Jesus as I do. And so there's a church on every corner. There's 22 churches per 100 square miles. The national average is 9. So it's very difficult for someone who's on the registry, even level 1 folks who are almost no threat to reoffend, to find a place to live or work that's not in proximity to a church. So for those reasons, I oppose that 10-year minimum that's found in the bill.
Thank you, Representative. Any questions? Representative Miller.
Thank you. Thank you, Representative Kennard, for your response. Are you aware of, and I know you have spent some time with this issue, are you aware of any problems with the sex offender registry statute as it existed prior to the proposed amendments in 425 relating to the amount of time that has occurred? That, in other words, why are we making this change in your estimation? Do you have any information about something that has happened or what might have caused this?
In my anecdotal experience, I have not run into any problems that just 5 years creates. Now, there's other things that creates problems, like the house of worship restriction. That's very problematic. And a lot of nonprofits, we cannot work with folks on the registry because of that particular issue.
Okay, thank you.
Representative Gullett.
In Georgia today, do you know if you're tiered 3 today, with the way that the law is written, could you be removed from the registry after 10 years of completing your sentence?
I'm not confident, but I think you cannot.
Would you believe that level 2s could be removed from the registry?
I'm not sure.
After 10 years?
I'm not sure. My biggest concern is the level 1 low risk folks. That's where most of the people on the registry, that's where they are leveled. And I see that as where most of our problems with organizations like mine lies. So actually doubling the amount of time that they have to be on the registry, it really creates some real life problems.
Where'd you get the 5 years from?
5?
Yeah, did you say doubling it? 5?
From 5 to 10.
Where'd the 5 come from?
That's the way it currently sits, right? You can apply for...
No, today it says 10 years have elapsed since the individual completed all prison, parole, supervised release, or probation for the offense, which required registration pursuant to Code Section 42-112, or the individual has been classified by the board as a Level 1 risk assessment classification. Provided that the board has not done a risk assessment classification for such individual, the court shall order such classification to be completed prior to considering the petition for release. So there is no minimum today if you're a Level 1.
Isn't it true that Level 1 must stay on the registry for 5 years?
No. Not if the judge can release you, can terminate your sentence and release you.
Okay.
In my understanding. I'm not a lawyer, so not a judge either.
Okay, I'd still think 10 years is extreme for Level 1 threats.
Yeah, I think we're going to, we'll clarify that in just a minute. But Representative Crow?
Thank you. I'm trying to figure out if my question's already been answered or not. But I was just going to point out that the same thing that Representative Gullett had said. Mm-hmm. Currently, the way it's written, it's either 10 years, which would allow anybody on the registry, the way the code's currently written, whether it's Level 1, Level 2, or a sexually dangerous predator, or Level 3, would allow them to be out. And I think we've dealt with this in the last couple of years. I know I've heard several bills over the last couple of years dealing with this issue, and I think I remember you testifying in some of those hearings before. I always thought that it was supposed to have been an and in this position, and I don't know if it was a typo when we missed it or what happened, but I had always thought it had been that they had to be in 10 years, and then Level 1, the only ones that could be released was the Level 1s after 10 years. So I appreciate you bringing this. That was my understanding the whole time, and I know 10 years it seems like a long time to you, but to many other folks, I think there needs to be a certain amount of time to make sure that we've gotten a standard amount of time to make sure that they're not a risk to reoffend. I know they are a lower risk to reoffend, but they're not a zero risk to reoffend, and I feel better having a preset amount of time to make sure that we're diligent in making sure that they've been able to finish their probation, parole, sentences, and all that, and then function, for a certain amount of time without reoffending. So that's why I am in favor of that, and I thought it was already that way. So I appreciate you bringing the bill.
I respect that. The problem is with all the suffocating restrictions on a person that's on the registry, there is no nuance between 1, 2, and 3. The same restrictions, distance restrictions, apply to all levels. And like I said, Georgia is an outlier in that regard. There's no other state that puts a restriction on proximity to a church for their Level 1, and 47 other states don't have a house of worship restriction at all. But that particular thing is very limiting, and I believe it creates a public safety issue. When someone is unstable, they can't work, they can't have a place to live, I think you increase their chances of reoffending because of that.
All right, thank you, Representative. I don't see any more questions. Thank you.
Thank you.
Representative Gullett, can I quickly, I think we had few members with the question. So currently as it stands, it's either 10 years or if you meet the Level 1 risk. And that Level 1 risk can be met at any time? Is that correct? Yes. Oh, I'm sorry.
Yeah, my understanding is that if you terminate your sentence, a judge, the people who get their sentence either complete their sentence, but they want it earlier than the 10 years, and their sentence, their probation is when their probation ends or whatever they're on ends, they can petition to be removed from the registry by the judge, and the judge can grant that before the 10 years.
Okay, thank you. Joey Villames. Good afternoon.
Good
If you
afternoon.
can tell us what group you're with.
My name is, thank you for your time. My name is Joey Villamez. I'm from Probation Information Network, and please forgive me, I'm just now seeing the sub today at this meeting. So this statement was written with the intention of addressing just the or to the and. Like I said, my name's Joey. I'm from Probation Information Network. We are a research and consulting firm specializing in post-conviction rules and restrictions. One of my areas of expertise is the variations in SORNA requirements across the country, SORNA standing for the Sex Offender Registration and Notification Act. My research on this topic has been peer-reviewed and published, and I have presented at academic and legal conferences. To address any concerns regarding registrants from other states traveling to Georgia to be removed from the registry, each state has its own registry. If someone is removed from the registry in Georgia, which is no easy feat actually, then decides that they want to relocate to another state, almost every state statutes would still require them to register. This is because the language of the statutes in almost every state will require registration if someone has ever been convicted of committing a sex-based offense. It doesn't matter if they've been removed from the registry here, there is no reciprocity. They would still have to register if they moved somewhere else. So someone simply relocating temporarily to Georgia with the intention of being removed from the registry and then leaving Georgia would be wasting their time and money. And while they're here, they would be subject to harsher registry restrictions than the majority of the country, because Georgia is on the stricter side of the spectrum when compared to the other 49 states and 5 major territories included in our study. Contrary to public perception, studies have repeatedly shown that the majority of sex-based offenses are committed by people who are not yet on the registry, and the majority of people on the registry never commit another sex-based offense. Expanding the registry in any way, including extending the required duration of registration, would be a waste of valuable resources and provide no additional public safety. It is also important to remember that the registry includes an overbroad multitude of offenses, many of which are nonviolent. Despite this, these individuals are consistently excluded from criminal justice reform legislation, as we've seen in this room recently. Existing statute offers a path to removal from the registry for individuals who meet certain criteria. Someone who has, as Representative Gullett has mentioned, completed all prison, parole, supervised release, and probation, has been deemed by the courts to no longer require oversight. Someone who has been classified as a level 1 risk assessment classification has been evaluated by a panel of experts and found to present a minimal risk of recidivism. Individuals who meet both of these requirements, both of these criteria, have most likely already spent a considerable amount of time on the registry and are worthy of consideration for removal. Consideration being the key word, because even at this point, removal is far from guaranteed. It is not an automatic process as it is in some other states. An individual who is eligible must petition for removal in court, and a judge must rule in their favor. If that judge feels that more time on the registry is warranted, they will rule accordingly. There is no danger in letting this lengthy, multi-step, carefully safeguarded process for removal begin earlier for those deemed eligible. This bill would unnecessarily require more time on the registry for the very people who have been determined by experts to present the absolute lowest risk of reoffending, and only those truly deserving are removed from the registry here in Georgia, and those who are truly deserving deserve the opportunity to plead their case sooner rather than later. Thank you.
Thank you for your testimony. Any questions? I've got a question. Do you know what are, I know you specifically spoke about just people having either registered or released in other states coming to Georgia. What's kind of the pattern in other states of people coming to their states if they've been released in other states? Do they have certain requirements as well?
As far as if I'm understanding correctly, if they've been removed from the registry in one state? So the way that the statutes are written in almost all, and I don't recall the exact number or which states it is different, but it is going to be a maximum of maybe 3 or 4. So 40-something states. The language of the statutes is that if you have ever been convicted of committing X, Y, or Z, right, the list of sexual-based offenses, then you would be required to register in that state if you either move there as a resident, are employed there temporarily, are enrolled in school there, or visit for any lengthy period of time. So removal, there is, to my knowledge, as of the end of 2022 when our study was conducted, there's no reciprocity in the vast majority of the country. If you've been removed here and you move to California, you're still going to have to go back on the registry there. So moving here just to get removed would be an exercise in futility, if you ask me.
Okay, so if you were removed in one state and you moved to another state, you're still having to register based on the amount of time that that state requires you to have been registered. Is that correct?
I believe there would be processes in place for you to apply to be removed because you've been removed where you were. They might have some kind of system in place where you've already been on the registry in 10 years and you were removed in your home state. So when you get here, you're still going to have to register, but then you might be able to go through a court process, and that might bolster your argument for removal. But with the very few states, and I think it really is just 3 or 4, whose statutes are written, if you are required to register where you currently live and relocate here, then you would have to register. So I'm not a lawyer, but by reading that way, I would think that would imply if you've been removed in your home state, you are no longer required to register. Therefore, if you move to one of those 3 or 4 states, I guess that would be a type of reciprocity. But that is very much in the minority.
Gotcha. Okay. Thank you so much. Thank you. Tracy Alvord? Alvord? Good afternoon.
Good afternoon. Thank you, Madam Chair and committee members. I'm Tracy Alvord with the Sexual Offender Risk Review Board, and this is Marcus Viegel. He is my research and training expert, so I thought if there's some questions you have that I can't answer, he can answer those.
If you can bring the mic closer to you, sorry. Thank you. And if will you be speaking? You guys can move the mic or however, we just need to make sure that you guys are heard. Thank you.
Thank you. So there's actually 2 parts to this bill that I want to address. The first part being about out-of-state sex offenders moving into Georgia, and then the issue, the 10-year issue. I think I can probably answer some of the questions that you all had regarding some of those things. But with the out-of-state sex offenders, I know that for SORB as well as DCS as well as for the Sheriff's Department, we have a lot of problems with sex offenders moving into Georgia, which we consider sex offender tourism, because they're trying to come off the registry. And it is true that if they come off the registry in one state, and they move to another state, they have to register again in that state. But they're not necessarily leaving Georgia. So that's the thing that we need to look at. And the problem for SORB in classifying out-of-state sex offenders is obtaining the information on those offenders that we get on Georgia sex offenders is vastly different. So I'm going to get out, is it okay if I hand you out some information? Yes, that's fine. So I brought 2 reports of two very similar reports, the same type of offense, and one is an individual who committed his offense outside of Georgia and moved to Georgia, and the other individual is a Georgia offender, and how we classified them. So what you're going to see in these, and I'll wait till you get those, and I kind of point out the differences. You can see them side by side. And I want to thank Representative Gollitt for adding this piece, because this has been a huge issue for SORB and other law enforcement agencies dealing with these out-of-state sex offenders. As they're passing that out, just to kind of let you know, just on SORB's database, we have, just from Florida, which Florida is a lifetime registry, and as Representative Gollitt had stated, that they can't come off the registry except for unless they're a juvenile. And so we have currently in our database, this doesn't include all of the Florida folks, but we have 700 Florida convicted sex offenders on our database alone that we are needing to classify. 700. That doesn't include Alabama and Tennessee, both of which have the Adam Walsh Act and tiering process. Very different because with the tiering, Adam Walsh, they classify based on conviction, not based on risk. So Georgia, we do classification based on risk. We look at all the information to make the best possible determination as to what their true risk is, not what is based on the offense, meaning the age of the victim or the type of offender that it is and how they make that decision. So when you look at these two, if you look at case number 17729, and you see that both of them are related to internet offenders, similar age group. But you'll see that in 17729 on page 2, he has, first of all, on page 1, he's out of Indiana. He has 3 probation violations. SORB has no access to other state probation behavior. So I really appreciated the comment about how we want to see patterns of behavior. How are they doing? Are they doing better? And that should tell us whether they should remain on the registry or not. And in Indiana, we see 3 probation violations. We have no information on that. Prison behavior. He was sentenced to serve 2 years, an alternative sentence, and I'm not really sure what that means exactly. But if he did do prison time, we'd have no information about his prison behavior. In Georgia, or with the way that we do classification, which what we do is empirically related. It's research information. This is not just based on opinion. This is not just based on, because we feel really bad about what happened, because this is very different from prosecution and incarceration. Because if we're looking at incarcerating somebody for what they did, they probably deserve a lot longer than they're getting. What we're looking at is once they're out and they've been caught and they've been prosecuted and they've been in prison and they've had those things happen, what's their risk to sexually reoffend? Well, if an individual's in prison and they're exposed to a correctional officer intentionally, they're not just masturbating in their, in their cell, they're actually exposing, that's a sex crime. And that increases their risk for sexual recidivism. In other states, we don't have that information, so we don't know. We don't have any treatment-related information. So what we know is there is a reduction in risk when a person completes specialized sex offender treatment. We don't know any of that. In Georgia, all sex offenders who come out into community supervision, or most sex offenders, are required to attend specialized sex offender treatment. They're required to have a psychosexual evaluation, and they're required to undergo polygraph examination. Again, to track their patterns of behavior. Are they really doing what they're supposed to be doing? Because we know sex offenders are very secretive and very manipulative. And so with Georgia information, we have all that. So when you look at the out-of-state offender that we had to level, and honestly, I tend to not prioritize these cases because they make me very nervous, because I feel like we're completely underestimating their risk because we don't have information. He's a level 1. If you look at 29800, who's our Georgia offender, who also has probation violations, we have his community behavior information. We know the risks that he's presenting. We know what he is doing based on the observation from the DCS officer. We know his treatment and what he's been doing in treatment. We know his polygraph examinations and the outcomes of those. We know the risk factors in this particular case, which made him a level 2. Very, very similar cases, different information that we had availability to. So with the out-of-state sex offenders, and I've spoken with several people, including we've had ADAs on our board, and then various agencies, and the conclusion, and actually it was recommended to me a couple of years ago, that it makes sense that where they were placed on the registry to begin with before coming to Georgia is where they should have to come off first, and then if they come to Georgia, then they can petition, as long as they come off of that registry, petition us to be able to come off, and I believe they should have to wait 10 years post. I believe in the out-of-state side, because we can't track their behavior. Whereas with Georgia sex offenders, we can. So if they are coming off another state, so let's say they're sentenced in Florida, they're required to register in Florida, they move to Georgia, they should come off Florida's registry, and then if they come here, then they can petition to come off our registry if they're 10 years post-supervision.
And level 1.
And level 1, yes, thank you, Marcus. Granted, they have to be a level 1. Because it gives us a little bit more time. We have 10 years at least to kind of see how they're doing with that. So that's my big push and for the out-of-state sex offenders. And we've had, it's frustrating for the DCS officers to manage them and monitor them because they don't have the information. It's frustrating for the sheriff's departments because once they're off of supervision, monitoring them because they don't know their history. Even us getting information from their states, Florida is one of the worst, where my investigators are constantly contacting Florida representatives and law enforcement to get their documents, their criminal documents, just in their criminal history, and it's very, very difficult to get it. We spend a lot of time and resources, well, we don't, because I don't make them a priority, which is a problem too, but I'd rather them not be leveled than be wrong in what we level them as, because if I say he's a level 1, like we did it with this one guy, and he's really probably maybe not a level 1, then we're reacting to this individual incorrectly and monitoring them incorrectly. So that was the piece of adding the out-of-state sex offender issue, that because right now they're just coming in, and we've had about 1/3, when I was looking at our numbers of those, so we received the court orders requesting a petition to come off the registry. About 1/3 of those are out-of-state sex offenders. They're trying to come off. Now, whether the judge is allowing them off or not, I don't know, but I do know that at least 1/3 in the year of 2023 was asking for that. Do you want me to just keep going with each of my pieces, or do you want to ask questions? You may not have questions about the out-of-state people.
If you can just finish your testimony, and then we'll do questions after.
So the second piece is, one of the recommendations that we had made regarding the 10-year was that, and again, we come from the perspective of best practices, empirical evidence, and how can we best monitor sex offenders. And I think that the registry is very watered down because we have so many people that are on the registry. There's 38,000 sex offenders on the registry. That requires our supervision officers, when they're on supervision, and our sheriff's departments to monitor all 38,000 sex offenders. That's a lot for them to monitor. So what that means is that they are having to equally monitor level 1s, level 2s, and sexually dangerous predators. In other states, they actually, and I can't say exactly which states, but there are states that don't even register their level 1s. They focus their time and their attention on your level 2 and predator cases, because those are the most dangerous. Right now, if we look at the stats from SORB, approximately 45% of those we level are 2s and predators. So 45% of individuals that really need to be watched are not being as effectively watched, because we got another 55% that we're spending a lot of time on. And that's my biggest concern with having level 1s wait another 10 years. For SORB, when we have an individual who's going for removal from the registry, typically, and not all the time because I don't know how often it happens, if it's an outdated classification, the judge will order that they be classified again. The district attorneys are doing a great job. They know us very well. I have talked to them about it's really important that's updated. And so we have that information to show the patterns of behavior. So if we have an individual who he's been on probation for the last 10, 15, 20 years, and we know that that can happen, and they have completed treatment, they have had no violations of probation, they've had no issues that would suggest risk, and yet they're waiting another 10 years yet to come off the registry. Again, we're being immersed in numbers that we don't need to be immersed in. We really need to focus on this level 2 and predator guy. Our recommendation had been to take out the 10 years and say that the only individuals that could come out, be considered for removal from the registry, would be those that are a level 1. Because right now it's true that if an individual waits 10 years post supervision, they can be a true predator and come off the registry. And we do not agree with that at all. They shouldn't be able to come off the registry until they are a level 1. And so our changes, which is just you have to be a level 1 and you have to have an updated classification that's no older than 5 years, should you be able to be considered for removal. So just to give you an idea, in 2023, only 207 individuals were removed from the registry for a court order. There were 616 new convictions of sex offenders in the year 2023 that we received. We don't receive them all. On average, since 2006 all year through, on average, we get 1,700 new sex offenders placed on the registry every single year. So when we really look at how much there is, how can our people really focus on these really dangerous people? And that's really our focus. It's just about how can we better monitor our very dangerous individuals. And I think that's all that I have.
Okay. Any questions? I have. Okay, go ahead. No, go ahead. Representative Miller.
Okay. Thank you. I just wanted to make sure I'm because I'm trying to follow this, and that's not my area of extreme expertise, sort of post-registration post conviction, what happens with sex offenders. Okay, so the proposed change in this bill, do you agree or disagree with the 10-year period? In other words, would it just be easier for someone to finish their sentence and be a level 1 and then petition? Is that what that be? Is that what you're saying would make more sense for you?
So, yes, I believe that an individual should be a level 1, and once they're off of supervision, if they're a level 1, they can petition at that time. But if they're not a level 1, they should never be able to petition until they are a level 1. And they do have the ability to do that. So, we have individuals who are level 2 or predator. They do have due process. And in Representative Sain's bill last year was passed that 10 years post-classification, they can request to be reviewed again. So it's a new review. So it's not. So one of the issues that other states are having, Florida is included in this, is when they have to register for the rest of their life, their civil issues. And so there's a lot of hearings associated with that. I have states calling me asking us how are we doing things to do things more like we're doing them, because they're not dealing with those civil issues, and there is some options for these guys.
Okay, thank you.
Representative Crowe.
Thank you. So so I'm clear, you're in favor of the 10 years and the level 1 for out-of-state offenders that relocate here.
Yes.
But the changing the or to the and, a couple of paragraphs before that, you are not as in favor of, because 55% of the people that are on the registry are level 1s, and that's taking up a lot of your time away from the others, right?
I mean, it's taking up everybody's time. My concern isn't so much our time. My concern is that it's taking up the time of our law enforcement, whether it's probation or the sheriff's departments, and trying to monitor these people.
So, and I know one of my concerns with the bill, I think it was 2 years ago when we did the 10, was it 2 years, 3 years ago we did the 10 years? Do you remember?
With adding that, are you talking about originally changing it? It used to be lifetime in Georgia.
Yeah.
And then in 2010, they changed it to how it's worded now.
Okay. We had another bill 2 or 3 years ago. It may have been Sainz's bill last year. It was your bill.
In public safety.
Okay.
It was the same exact as the original bill.
Yeah. So the fact that they can be a level 1 and come here and immediately petition, is that what is leading to, you think, you used a term and I don't remember it, and I don't want to try to say it because
sex offender tourism.
That's the one. Yeah, I was going to get that all wrong. So this would help alleviate that by adding the 10 years, because, and this is just to clarify for me, when they come in, you don't have their history.
Correct.
And so that 10 years would give y'all an opportunity to monitor their behavior, because you can't get that monitored behavior information from the other states easily or at all. Is that?
That's
right.
correct. Yeah.
But now, in just at the 10 years, and I understand, I know y'all are overwhelmed. I know y'all are overwhelmed, and you have way more to do than you could possibly handle. And the mandatory 10 years for even a level 1 that this would create would probably exacerbate that some and keep more people on there, because that's what this is doing, right? It says now they'd have to be a level 1 and be on the registry for at least 10 years post conviction and sentencing and all that. That's what this one change is making, changing it from or to and, correct?
It does, but that doesn't affect SORB. I don't know if you're referring to the registry or to SORB's
Okay, well,
job.
So it would be, who would it affect negatively then? The people monitoring?
It's for them to stay on
okay.
for 10 more years. Yes, people monitoring them.
Okay. Is there, in your opinion, is there more chance that they would exhibit behaviors that would make them, I guess, a greater risk or likelier to reoffend after they come off supervised probation? And I guess a better way to say that, because we're saying now that they can petition, they're a level 1, they can petition as soon as they finish their sentence and their probation or parole, and especially if they're this is a first conviction for them and they have maybe a 2 or 3 or 5 year probationary sentence, it's all probated, they do 5 years. My concern then is that while they're under direct supervision for those 5 years, it's a lot easier for them not to offend or exhibit behavior that would lead you to believe they're a higher risk of reoffending. After that 10 years, that's my feeling on the benefit of this, is that while they're supervised, and I didn't never deal with probation, I dealt in it on the front end, like the other side from from Representative Miller, but in the same world. So I didn't deal with as much on probation afterwards, but I've known a lot of folks that have, done that, and they did well while they were under sentence. Right. As soon as they come out from under sentence, then you start to see those behaviors reappear. And so that's my concern with not having the 10 years for that, is that we don't know what they're going to do as long as they're under direct supervised probation or supervision. So, but I appreciate the level of work that it creates.
Can I respond to?
Absolutely, please.
So, I think I love your point, and I agree in a lot of ways about that. I think that with the level ones, the highest time of reoffense, even if they're under supervision, is within the first 2 years of them being released from prison or being placed on sentence. And the other issue is that level one, so let me share kind of what level ones typically look like. Level ones typically are your young adult with the older teenage individual. So true statutory rape cases. So understand that we get statutory rape cases that are pled down, that are not really statutory rape, and we usually do not make them a level one. So there's a difference. And also incest cases and family cases. So typically, when you have an individual who's offending within the home, the registry isn't going to help monitor that whatsoever. And so I definitely hear what you're saying, and your level twos and predators absolutely fit under what you're saying. Those individuals, they need to be monitored for as long as we possibly can monitor them, as long as they're a level 2 and a predator, and show themselves to have a better pattern of behavior over a long-term period. Level ones, their type of offending is very different than what would be a 2 and a predator.
Representative Gullett.
Thank you. So 45% today are not level 1. Is that right? And I know that you analyze this based on risk and not what they've done, but are there any level 1s who have been convicted of aggravated child molestation that you're aware of?
I'd have to go back, and I'm sure that they have, because we definitely have, for example, biological fathers that rape their daughters. So, would they necessarily be a level 1? We probably do have one. So an example may be a biological father who is 50 and he rapes his 12-year-old daughter, and he has done his prison time and come out, and there's been no other issues beside that, so empirically he'd be a level 1. The likelihood that he has molested other children in the home or future molesting other children in the home is probably somewhat decent. Now, empirically, they would suggest otherwise. I don't agree with that, because I think it's very easy for sex offenders of that type to get away with it, because family members, it's a very secretive environment. The registry is not going to do anything to protect that. So the level 2s and the predators, who are the ones who are going outside the home, the ones who are going to the parks and watching children, the ones who are going to schools and picking children up to then take them somewhere, picking up a hitchhiker and give them a rapist, serial rapist. Those are the ones that the registry really helps us with, and really monitoring them.
So outside of monitoring, though, doesn't the registry offer other benefits to the public?
Yeah, I think probably everybody wants to know every single sex offender, where they are and what they're doing, and I think I'd be curious to know who really has looked at the registry, how recently. I think it's become not as valuable to people or as serious to people, because there's so many that are on there. And I think that the argument typically is that they see somebody on there and they're like, the comments I'll hear is, this is an individual that's statutory rape. This is an individual who we don't even know what they're doing, because the difference between Georgia registry and other registries is some registries actually have details of what they did. Georgia doesn't have the details, so if it's a small child or a teenager or whatever. So, I think that there's some public sense of safety by having the registry and everybody listed on there, but in truth, there is less safety by having everybody listed on the registry.
Yeah, I think we just disagree on that one, but I appreciate your thoughts on it. One quick question, too. Isn't it true, I wish they were here, I know you're looking out for our sheriffs who are having to do this, but that the Sheriff's Association is in support of this bill?
I don't know. They may not be. I think that, again, there's an underlying emotional factor that plays a role in wanting to know where somebody is all the time. And there's a lack of recognition that when our law enforcement has to take their time to watch those that are less risk than those who really present a significant danger. My concern, I know I have children, I would want them to focus on twos and predators because I know those are the ones I'd be really scared of. The level ones who it's the dad next door and the stepdad and the mother and the whoever, I know that they're, other than me being a parent, that I'm supposed to be taking care of my children the best way that I possibly can, in addition to having knowledge and information. I'd rather have knowledge about, in this registry, being functional in the sense of knowing who really is extremely dangerous. We can look at them as all dangerous, and I think people do. I mean, these are considered the worst of the worst people, and I get that. The issue, though, is really being able to protect our communities, and this is what this is about for me, protecting our communities in the best way possible. And I don't see that being able to be done when there's so many people on the registry. I think it just makes it more difficult for law enforcement.
Thanks.
And I just have a quick question. I was just curious. Who and how do you get information for the out-of-state offenders? I know you had mentioned that you're limited in the information that you get, but the information how do you get the information, period? And then is there not a mechanism for you to ask the other states for additional information, criminal history, anything like that?
So we get a monthly report from the GBI of the new out-of-state sex offenders who register. And so on average, between 35 to 65 new sex offenders from other states register in our state every single month. It took us years just to create a relationship with various states to even get their criminal documents, because we don't just get their sex offense. So part of considering risk is, what does their criminal history look like? Is there violence in their criminal history? Is there behavior that is suggestive of sexual behavior, such as continuing delinquency of a minor or murders, things like that? All those things are considered in risk. So we are having to go from state. We have one sex offender who committed 3 separate sex offenses in 3 separate states. So I will prioritize those really high-risk cases, and we have to go to each state begging them for information. Some states are better than others. Others, one issue obviously is if they're telling us we have to pay a ridiculous amount of money to just get their criminal documentation. So that's one of the hurdles that we might have in some. Others, that they have the backlog and they can't get to us. So they send us from one person to the next person to the next person. There's so much time and effort involved in that. With treatment particular records, we have in our legislation that we have access to that. So we're legally provided that information. In other states, we know HIPAA is a part of treatment-related issues. Probation, it took us for, when SORB first started, we had DCS and Pardons and Parole were separate. We had DCS, well, it wasn't DCS then, probation was allowing us access to their records, and the prison system, we had to create special legislation to get pardons and parole information. So other states, that's just a whole nother territory. And so anytime we've tried to get that kind of information, we know we're not going to get treatment information because of HIPAA. But trying to get anything about their community supervision, that type of thing, is almost impossible. We have the same issue with the federal government, trying to get any information about their probation, even when it's in Georgia, is really, really difficult. So other states, it's almost, it's impossible.
Can I add something to that? So what the 2 reports really point out is the difference between historical risk factors, which are already done and aren't going to change, and what we call dynamic risk factors. And through the GBI, we get the national criminal history, so we know what crimes they've committed, and our investigators work really hard to get us the criminal documents of what were they committed of and the police report. That's all the historical factors. What we don't get is the dynamic factors, and they often make a difference. And it's their behavior, the dynamic factors that would occur during those 10 years that we get through Georgia, because we have great access to the DCS officers' notes. And so we read every single note they put in. And if there's a dynamic risk factor that we identify, we put it in our report. And that's why the Georgia person ended up being a 2, because of these changeable dynamic factors. And so that's really where the information difference is in terms of historical, we get them for both. But for these really important dynamic factors, we just can't get at it. And there's not, we're not going to get access to another state's prison or probation records like we do in Georgia.
All right, great. Thank you. And that's all the questions. We have one last, Maisie Lynn.
Was I on the list to speak?
You are.
Oh, I apologize. I thought.
Did you sign up?
I don't know. I did not. I didn't have anything. Because I had one more point I wanted to make.
Go
I'm
ahead.
allowed.
That's fine.
And it kind of addresses your concern. There's a principle called the risk need responsivity principle that's being researched a lot currently. And what it really says is you determine what the risk is and then treat them accordingly. So if you treat a high-risk offender like a low-risk person, they're going to be a much higher risk because you're not providing the safeguards that you need for a high-risk offender. What the research is finding is that when you treat a low-risk offender like a high-risk offender, they end up acting more like a high-risk offender, and their risk of sexual reoffense goes up. And it's a little common sense. You treat somebody like a criminal, eventually they're going to start acting like a criminal. And that's where really sort of the movement in the field is treat low-risk offenders with less treatment and less restrictions, and really focus on the high-risk offenders and give them intensive treatment, and lots of restrictions and safeguards and monitoring. And so that's where the inclusion of the 10 years for the in-state offenders kind of contradicts that needs-risk responsivity principle that's being researched. Thank you for your time.
Thank you.
Thank you. Sure.
In that study, if you don't mind.
There's several, it's in the sex offender research community. I think Hansen has done some studies. I could get you more names. There's a lot of different researchers that are doing it. I think Thornton's done some work on it. It's been one of the sort of big trends in research over the last 10 years in the field of sex offender recidivism research.
Okay, all right, thank you. If you happen to get that and want to shoot it to me, I'd appreciate it.
I'd love to. I just need an email address.
Okay.
Thank you.
It's okay.
Thank you, Chairman. I will be as brief as I can. I know you all have been here a long time today. And really, I am not raising any concerns with the tourism aspect of this. I can appreciate all the things that have been said about that today. Our concern is not unlike Ms. Alvord's with respect to the or becoming an and at line 60. By way of sometimes when you get a piece of legislation, it's not necessary to include some of the ancillary pieces that tie to it. You wouldn't want that to happen, right? You would never be able to read all of the things. But something that you aren't seeing that is part and parcel of this process is the criteria that are set out in OCGA 1710 6.2 C1A through C1F. And this is a set of criteria that in addition to someone completing their sentence, they have to meet in order to petition for removal. And it's things like the petitioner can have no prior sex offense conviction. And that includes everything from pandering to rape. The petitioner can have no prior conviction for an offense under federal law or another state that would equate to those things, to those other, to prior sex conviction in Georgia. They cannot have used a deadly weapon or object or device or instrument that would be likely to cause serious bodily harm. The court cannot have found evidence of any kind of relevant similar transaction, so behavior that might not have risen to the level of a prior conviction, but might look a lot like a sex offense that came out in the disposition of their case. The victim cannot have suffered any intentional physical harm during the commission of the offense, cannot have been transported during the offense. So, one of the examples that was mentioned was like picking, picking a child up, that person's not going to be able to petition for removal. Victim cannot have been physically restrained during the commission of offense. So the very worst actors are not accessing this petition process under the statute, much less this idea around leveling that we have. I want to give you also a picture of a potential person on the registry and maybe bring a little more life to what we've heard from today regarding the impact. So when you think about our, sometimes in the code we call them youthful offenders, and that's typically classified as 17 to 25-year-olds. So in a true, and I definitely agree with Ms. Alvord's, recognition that not every resolution to statutory rape really was a statutory rape to start with. But for those that are, one could be this. 19-year-old has consensual sex with a 15-year-old. This could be a senior in high school and a freshman in high school. Could be a freshman in college, sophomore in high school. They're all within this age range together. But that under our law is statutory rape, consensual or not. That 19-year-old then goes through a criminal conviction process, which maybe we could agree on that's going to take about 3 years from arrest to conviction. So now they're 22, and let's say they get a 10-year sentence, whether that's straight probation, 10 years to serve 2 in prison. It would be a reasonable, according to at least, and I'm sorry he's not here with me today, but a defender has been with me the last couple of times this bill's been on because he could attest to that being a reasonable sentence on that kind of a case in his jurisdiction, 10 years. So now this 19-year-old who's 22 when they get their sentence is on supervised probation. They might go into non-reporting at some point, but they are under carceral supervision until they're 32. And right now, it's true. If they, assuming they are level 1, they can petition for removal at the age of 32 as long as they've satisfied their conditions. So that person who had consensual, albeit illegal sex with their girlfriend at 19 will have been on the registry until at least 32 in my scenario. And if this bill were to pass with this and here, they would have to wait until they were 42 to ask for that permission. And when you couple that with all that you just heard about the supervision burdens, I will just leave however you would like to decide the outcome of that to you. I mean, to me, it seems like the fact that we are including some of the less dangerous offenses on our registry, it opens up these collateral consequences that you might not necessarily have meant to do. So we would encourage you to leave the and as an or, and would have no problem with the, I believe, if I followed the conversation, that because the first section there, it's true, does currently allow a level 2 or a level 3 person who satisfies all those initial conditions that I started off with, along with the 10-year lapse. If there was a desire to change that and limit it to only level, to prevent that from allowing level 2 and level 3, there would need to be more modification if you all are trying to only allow level 1s to gain access to a petition process without having to wait 10 years. So if you take what you've heard and agree that or is right, but you want to limit it to only level 1, there's still some modifications that would have to get made to this legislation.
Thank you, Chairman. I'm Representative Gullett.
So on the statutory rape, is that a felony or a misdemeanor? Or would it depend?
In the one I gave you is a felony because Romeo and Juliet doesn't apply to a 19-year-old. So you only get the misdemeanor escape valve if you're 18, and there's a less than 4-year difference, I believe, on stat rape. See, unfortunately, our our statutes aren't uniform, and so for some of it's 48 months, for some of it's, but it's either 3 or 4 years. But no, it's a felony because it's not Romeo and Juliet.
Because that's the confusing part that I think a lot of people try to say is, down here, and that's probably why you said it, to be honest with you, is because, we talked about it, and why I thought it got held up before. So this has passed Public Safety Committee twice, and now it's here a different term. And a lot of people have a hard time, I believe, not feeling empathy or sympathy for a high schooler in a relationship with a high schooler, and that dragging on until you're 42 years old, and that's not what the goal is. Birds of a feather kind of thing in most people's minds, but that's immediately what people go to. Man, I don't think they should be that situation, but I don't think that is a high majority of these situations. And if that's the case of a felony of 19, I don't know that many. I'd be curious to see if DAs are actually prosecuting it as a felony or if they're pleading it down to whatever. I would imagine that they're pleading it down to whatever, but.
Well, they would know who's on the registry. I probably have an idea of what.
Yeah, so you're talking about those type of statutory being pled down?
Or ending up on the registry because they're not pled down. I'm sorry, ending up on the registry because they're not pled down to something that would not require registration.
They're on the registry.
Well, we'll get to her. People
on
are
the
going to hear
registry.
online. So, but at the end of the day, I think that's like a red herring a little bit. Straw man. It might be one situation, but I do believe that tier 2s and tier 3s do not need to come off the registry. Is 10 years too much? I don't know. I don't feel like it is, but if that's something the will of the committee, we can change it. But I don't know. In my feeling and what we're trying to accomplish, if you have a judge in your area who's letting people, terminate it's not even that they fulfilled their probation, terminate their sentence. Hey, I've been good for probation for 5 of my 10 years. Will you let me off? That sounds good. Immediately as soon as they come off, hey, judge, you let me off. I'm petitioning to be removed from the sex offender registry. And that's happening in areas. It's happening in my area. And so that is a real scenario that no one talks about here, that these scenarios aren't fully, hey, it's now 20 years later. There's scenarios where that's not happening. And to me, that's a public safety issue. And so I appreciate the red herring a little bit. I understand it, but I do believe it throws us off course a little bit.
Well, I do respectfully take the red herring characterization with some offense because it is a true reality. It also happens in cases where someone's possessing images that were consensually shared with them because the registry requires registration for some of those crimes, no matter if the person is 19, 15. We don't have a provision for that. To the point around what's happening in Paulding, I did look into what we could find in the last 3 years. Now, what has happened within the past 3 years is that the courts have required petitions for registry removal to be filed on a civil track versus under the criminal indictment. Before that requirement went into effect, and I don't remember precisely when, it was kind of willy-nilly. A defense lawyer could just go ahead and travel under the same indictment, file the petition, and it was heard. But the courts began to realize that their workload assessment didn't capture that work because of the way it's structured. It's structured around the offense. It doesn't contemplate every one of them having a petition. So they asked that the petitions now be filed civilly. What I can tell you about Paulding on the criminal filings, not as easy to access the civil for me, is that 3 petitions for removal have been granted since 2020. And they were all granted by a judge whose last day on the bench happens to be today. I do not have the background of all of those or the rationale for them. I can't say if the judge modified their sentence at the time. But every step of this process is an adversarial one. And whether the sentence was modified, that happened in a proceeding where the prosecution represented the state and the judge made a decision. Every petition for removal, the state is made aware of, and it's an adversarial process. And part of the beauty of our system of justice is that it allows the people on the ground, the prosecutor, the judge, the defense lawyer, to take that case as it comes to them and make an informed decision about what's going on in that case. And so I can't say for sure why there was an inclination to grant those petitions. But the discretion is available, and they qualified under the law. And it's 3 in 3 years.
Do you have a question, Representative Gold?
Yeah, isn't it true that there was actually over 3 just last year? I know you can only look at part of
For
it.
the
but
criminal docket, that's
Yeah.
not true, but I would be happy to review the civil docket if I could easily obtain it.
Yeah,
It's just
my
not
district
easy.
attorney texted me, and it was over 3 just last year alone. But
Well,
and one last further, when brought up with the judge, our concerns, his response was, if you don't like being able to do it, change the law. So we are sitting here today working through the process. Thank you.
Thank you. Thank you, Maisie. So, Representative Gullett, with all the information and testimony that we received, I hope you will continue to have further conversations. But with that, I will entertain any motions. I do not see any. I will entertain any motions, if there are any.
Yes, ma'am.
Representative Crowe.
I will move to pass.
Is there a second? All right. All in favor of passing HB 425, say aye. All those opposed, same sign. I'm sorry. Was that a no? No. It passes. Thank you. All right. Last bill we'll hear today is HB 1033. Chairman Leverett. Would you like to stay there? You can. Okay. Just tell me which microphone. Okay.
Yeah, everybody else does.
Whenever you're ready.
Thank you, Madam Chairman. It's my pleasure to present to you House Bill 1033, which is entitled the Utility Worker Protection Act. We've got a few folks, I think, here today who would like to testify in favor of it. I know the committee's been sitting here for a long time, so I'll try to be brief in my comments. I will not say it's a simple bill, because I know that would raise everybody's hair up on the back of their neck and lean everyone in. It is conceptually rather simple, but the details do require a little bit of elaboration. So if you recall, last year we had the critical infrastructure bill that the House and Senate both passed and the governor signed, and that was to protect critical infrastructure, utility infrastructure, transportation, rail, power, all of that. And I appreciate very much the House's support on that bill and this committee's approval of that bill. And that provided for an enhanced penalty or sentence if someone damaged critical infrastructure. And so we took the criminal trespass statute and amended it. This is sort of the follow-up. Last year we protected the infrastructure. Now we're trying to give some extra protection to the people who work on and maintain that infrastructure. And we're doing so by adding a new category of violation to the assault, aggravated assault, battery, and aggravated battery statutes in the criminal code. And then we provide an enhanced penalty or sentence range, much like the statutes already do for other special categories that are deemed worthy of additional protection. So we start out with, in section 1 of the bill is the name. Section 2 is a new definition. There is a code section 16.5.19 in the chapter 5 of title 16, which has definitions. We add a new definition, which is utility worker. And that is any employee of, including any person employed by or under contract with, an organization, entity, or company, whether privately, municipally, county, or cooperatively owned, that provides, and then we list out the different kinds of utility services: gas, heat, electricity, water, telecommunication services, sewer services, cable or video services, internet services, or railroad services. So we're trying to capture as many of the sort of public utilities or the public infrastructure as we can. Then in the applicable statute defining these various crimes, simple assault, aggravated assault, simple battery, aggravated battery, we add an enhanced penalty if the particular crime is committed against a utility worker, as we've just defined it, while the worker is acting within the course and scope of their employment or is performing official duties at the time of the offense. That language repeats through all four of these statutes. So in other words, if the utility worker gets assaulted in the grocery store and they're buying groceries, that wouldn't necessarily be covered. But if they're out on some property trying to clear limbs or work on a power line or work on a rail line, then the extra penalty could apply. So if you just go through each section of the bill, Section 3 is the simple assault statute, and that currently is a misdemeanor for most simple assaults, which means the penalty is imprisonment for up to a year and a fine of up to $1,000. Section 3 changes it to a misdemeanor of an high and aggravated nature if the assault is committed against a utility worker while acting within the scope of their employment, and that's imprisonment for up to a year and a fine of up to $5,000. Then the next section deals with aggravated assault. The penalty for just a general vanilla aggravated assault is imprisonment for 1 to 20 years. Section 4 of this bill would change it to imprisonment for 3 to 20 years if the aggravated assault is committed against a utility worker while in the course or scope of their employment duties or performing services. Then we also hit simple battery and aggravated battery. Simple battery is a misdemeanor, so that's up to 1 year and up to $1,000. We make it a misdemeanor of a high and aggravated nature if committed against a utility worker while performing the job, and that would be imprisonment for up to a year and a fine of up to $5,000. Then on aggravated battery, that penalty is 1 to 20 years. Section 6 would change it from 3 to 20 years if it's against a utility worker. And the bill, if you look at the final Section 7, it just applies to offenses committed on or after July 1, 2024. I would note, just if you're familiar with these four statutes, there are already a number of sort of categories where we have an enhanced penalty against different categories, and I won't go through it all because it would take a while, but it's things like public school employees, batteries and aggravated batteries committed against members of the family, if you're on a public transit vehicle or in a public transit station, 65 years or older, just different kinds of categories that already have enhanced penalties, so we just followed that. In other words, this isn't necessarily an original idea we're coming up with, we're just trying to follow a pattern that's been established in code and utilizing sort of a structure that people would be familiar with. But we feel like this would be a good protection and for our utility workers, and I think some of the testimony you will hear is, unfortunately, we're not just anticipating this could happen, it's been happening. So we're trying to respond to it in this manner. Thank you, Madam Chairman. I'm ready for any questions if anyone has any.
I think you have one question, Representative Gullett.
Thank you. Enhanced penalties always are interesting to me because once you do one, you're kind of, we're always going to enhance, a new group is going to be added. A new group. First, it was police officers. You do something to a police officer, it's worse than if you do something to me. And I respect that, and I understand, these, but these are things that we continue to add. So it sounds like we're going to have testimony on what's going on for utility workers to need this extra protection that maybe you and I won't have if I get punched in the face or they get punched in the. It's a different, us doing our job versus them doing their job. What that means, and I do want to look at, but this is always one of those things that I've seen that we just continue to add and add and add, and at some point, a majority of people will be an enhanced penalty, and a minority of people won't be, and that's the slope that we're going, we'll get down to, and that doesn't really address your bill. It's just some comments on it, but I am interested in what's going on and with our utility workers, because when my lights are out, that's the people you want there when it's hot and no AC, and so looking forward to the testimony. Thank you.
If I could just respond to that briefly, Mr. Chairman, I would say I appreciate that concern, and I think that's a valid concern. I do feel like though you'll hear some of this testimony. There is a need for this, and we hope this will help discourage it. But I would certainly be in favor of sort of closing the door on that right after we pass my bill.
Of course. Thank you. Thank you for your honesty. All right, we'll go ahead and start with Kevin Curtin and Lee Swan. Good afternoon. Thanks for waiting.
I'll make this very, very brief because
If you
Chairman
can say your
Leverett-
name and
Oh, I'm
where you're
sorry.
from first.
Kevin
Thank you.
Curtin. I'm the Senior Vice President of Government Relations for Georgia EMC. We represent all the electric membership cooperatives across the state of Georgia. We serve about 4.4 million Georgians in about 73% of the land mass of the state of Georgia. Chairman Leverett did a great job of explaining what the bill does, and this is really a step 2 to House Bill 227, which everyone on this committee passed last year. We appreciate that, and the full House, was unanimous vote in the House. When we sat back and looked at that bill and the impact of that bill has been very important, we realized that the folks who work on that infrastructure need additional protection. Lee Swan is here to help outline why that is. Lee is the investigator for Georgia Transmission Corporation, which is part owner of the transmission electrical grid of the state of Georgia, and that's for the EMC portion of the grid. Lee's the one who investigates all the incidents around the state where utility workers have been threatened or there's been threat to physical infrastructure. Lee's background, he had retired from the DeKalb Police Department in 2008, 25 years of law enforcement, 16 years with Georgia Transmission. He's been post-certified for 41 years. So he has a lot of experience in this field. I'll turn it over to Lee to talk about some of the instances around the state.
Well, thank you. First off, I want to again thank you for passing the legislation that assisted us last year in the protection of the critical infrastructure here in the state. That was precipitated by the incident that occurred up in Moore County up in North Carolina, and we certainly don't want to see anything like that repeated here. So again, thank you for doing that. In relation to the threats to the utility workers, this is a very real problem that affects not only the electrical industry, but also affects basically any utility industry you could think of throughout the state here. When one says utility worker, typically the type worker that pops into your mind is electric utility. But you've got your telecommunications, you have your railroads, the people that work on the rights of way there. You have foresters who work for us clearing the right of way that keep your right of way and your transmission lines free of what we call danger trees, which are trees or obstructions that can fall and ground out lines, therefore interrupting service to the members. So, you know, the utility industry encompasses a wide array of professions, basically. And as the gentleman over here indicated that when your lights are out, you know, not a whole lot you can do. You know, it's kind of tough to watch TV by candlelight. It's these workers that are encountering the problems that we increasingly see from the general public. There have been instances where people have shot at our utility workers who are working on the right-of-way, inspecting transmission towers, transmission structures, or trimming trees and whatnot. We have people who have threatened to shoot them, threatening to sabotage the equipment when they're not there, and they leave the equipment on the right-of-way to come back the following day to finish work. So we have a variety of these problems that are encountered. It's not a decreasing level of activity, it's an increasing level of activity. Now, what Georgia Transmission has done is that to try and diffuse these situations as much as what we can, is that we have identified a lot of our problem areas so that we know beforehand where we're going to run into problems. And if we have problems with particular landowners, our people try to negotiate with them to determine, okay, well, what is it that's the problem? How can we work around this? We will do just about anything we can do to get around the problem, to alleviate the situation before it gets there. If that fails, or if for whatever spontaneous reason the person, the landowner, the lessee, whatever, just is totally uncooperative, then that's when we generally go ahead and bring in off-duty law enforcement to accompany the crews. This is very time-consuming, not only in scheduling, but also very costly to us, which in turn we have to pass that rate on to someone else. And the someone else is everybody that's sitting in the room here. So it's a very disturbing problem to us. We've had situations where landowners have come up to workers that are trimming trees on right-of-way and tell them that I'm going to blow your head off. point guns at them, okay? This is what we would call a problem, okay? Now, admittedly, to the gentleman over here that stated that, you've got enhanced penalties for various other occupations, this is true, but that's because of a need. There was a need because of these particular professions encountered problems that are not encountered by your local John Q. citizen. So in the performance of their duties, you've got to look out for these people, because these are the people who are establishing services to keep you in business, to keep your businesses running, to keep those of your constituents online. Companies who are making whatever products, they just can't work without electricity. Nothing in this world is going to work without electricity. These lights in this building, the air conditioning, the heat, the computers, nothing works without electricity. So, and again, electricity industry is just one of many that's critical to the infrastructure of the state. So, having said that, thank you, and I'll entertain any questions you have.
Thank you. Chairman Smith?
I want to thank, first and foremost, Chairman Leverett for carrying this bill. This is much needed legislation. Thank you all for coming here and bearing with us. Welcome to Judiciary Non-Civil.
Thank you. It's quite an experience.
If it went about 2 more hours, we'd probably just made a motion to pass and got on out. My question is this. Got a lineman up on the pole, and somebody takes a shot at him. They try to duck, avoid from being shot. They hit a line. May not be the bullet that kills them, but how many volts are going through that line that they may come in contact with trying to avoid somebody shooting at them?
Exactly.
I mean, how many volts usually goes through a standard power
You
line?
can, if it's on a distribution level, it could be what we call 7.5, which is 7,500 volts. Or on a typical transmission line in Georgia, the highest transmission lines we have are 500 kV, 500,000 volts. So it could be anywhere in between there.
Gotcha. Thank you. Appreciate y'all's hard work.
Thank you. Thank you very much.
Representative Crowe?
Thank you, Madam Chair. Just curious, why are these folks shooting at people working? I mean, is it just right-of-way disputes? Is it because they feel like they're on that land and they don't? I mean, I'm just trying to figure out what's precipitating the rise in this.
A lot of it is the fact that these people have been able to do this for years and there's been no repercussion. They've done it one time, nothing happened. They do it 2 times, nothing happens. They do it 3 times, and they just keep on going. Our people only work under very strict guidelines with regards to staying, in the example of the right-of-way, they stay on the right-of-way. The rights-of-way are generally, say, about 75 feet from center line of the transmission line out left-right. So you've got about 150 feet there. If it's off of the right-of-way, unless there's a specific purpose or reason for them to be off that right-of-way, they're not going to be. Our contractors, and generally those of any electric utility, they're going to be very courteous. They're going to be very responsive to whatever it is you want. If the landowner or whoever approaches them and says ABC, they're going to do their best to do what they can to answer that question or address that problem at that moment in time. If that contractor cannot, all they have to do is pick up the cell phone and call for the local forester that handles that region. They can be over there and answer the question, or they can certainly be in touch with them. We do everything from repair fences, put up gates, shrubbery. We replace trees, landscaping, turf management, and so forth. I mean, anything we can do to make these people happy. Some people just don't like it. Most of the property that we work on, as far as the right-of-way goes, are considered easements. We don't own them. So the property owner can do whatever they want within the confines of the easement, which is generally most everything with the exception of, say, putting in a swimming pool under a transmission line or building a building or something of this nature. Agriculture is no problem. But again, some people are just the way they are.
Chairman Leverett?
Thank you, Madam Chairman. I didn't have a question for the witness, but he had mentioned somewhat obliquely an issue I felt like did merit some just brief mention as part of the issue and part of the reason for this legislative strategy, if you will, creating a special category in these 4 different crimes, is that these things have been happening and they are reported and there's no follow-up, there's no prosecutions made. And I understand that can be because of a number of circumstances. There may be concerns about proof or what have you. But we're kind of hoping that by creating this special category, we'll at least send a message that at least the legislature believes these cases are worthy of consideration, and perhaps that'll communicate some sort of message that does mean that the next time it happens, some sort of action will be taken, and then it won't happen another time in that community.
Thank you, Mr. Chair. Thank you.
Thank you.
Craig Camuso.
Madam Chair, if it's okay, I'd like to have the other gentleman join me.
That's fine. If you can both just introduce yourselves
Yes, ma'am.
before proceeding. Thank you.
Thank you, and I will try to be brief as well. I know the day has been long. My name is Craig Camuso. I'm with CSX Transportation, the railroad. I'd like to go ahead and introduce Mr. Patrick Folsom, who's representative of the Sheet Metal, Air, Rail, and Trainmen, which is the SMART union here in Georgia. Mr. Folsom, I actually started talking once the once the meeting started. We thought it would be great for both of us to be here. I'm here speaking today not only on behalf of CSX, but on behalf of the Georgia Railroad Association, which represents 2 Class 1 railroads, that would be CSX and Norfolk Southern, as well as 23 other short line railroads. In Georgia, we have over 4,500 miles of track, as well as over 5,000 employees combined. We are number 1 in the South in the number of track miles, in addition to the tons that originate from the state, as well as to the tons that is transported into the state. And safety and infrastructure is of paramount importance to us. And again, I'd also like to thank Chairman Leverett for the bill that he authored last year, which is also currently moving through the Florida General Assembly as we speak. We speak very much in favor of this legislation, not only for our company, but also for our employees, which are certainly the most valuable thing that we have. I would like to add a couple of items that was mentioned by the gentleman from the EMC. We too have issues with our right-of-way. When you talk about 4,500 miles of track, there's a lot that's done outside. And part of that is making sure that our lines are clear for good sight distance, as well as for the opportunity for the trains to operate. I have personally, while I don't operate on the railroad, I have personally, however, been involved with an instance where we were clearing a sight distance at a grade crossing in rural Georgia, and our crew was threatened with a gentleman with a shotgun that came out because he didn't want us cutting down his crepe myrtles, which also happened to be on our right-of-way. I got involved in that to making sure that we were able to work that through. Our railroad police, of which we have about maybe 4 that cover the state of Georgia, he could not be here today, but he talked to me about issues that we have with rocks being thrown at locomotive engineers and conductors. And Mr. Folsom actually has a personal experience that he can share about this. But we've had rocks, we've had robberies occur on our trains, and I know that falls under a different code section, but it's still very important. We've had a railroad policeman in another state that was attacked with bricks from above a bridge and suffered very, very severe injuries, as well as an employee in Louisiana that was killed during a robbery as he was on the train. So these things do happen, and we are seeing as we move forward that this is happening more and more. People are getting a little bit more brazen. I would like to just call on Mr. Folsom, if you could, who has, like I said, personal experience.
Hey, thank you, Madam Chair, and the members of the committee. I appreciate it. I am Patrick Folsom. I'm also a federally certified engineer and conductor. Also the chairman of the Board of Commissioners in Brooks County. And I do have personal experience as of being shot at. As an engineer, I've traveled all over the state of Georgia running a locomotive, and there are certain areas that we do know that's really could be kind of crazy at times. It could be at certain times of the night and where the location is, but not only just rocks being shot at. You have to understand when you have conductors walking the train in sidings in different places here in Georgia that people can get assaulted. And I do represent members of both railroads, and I have members that have come to me and been in those situations, and it's pretty scary. And let's not forget, being a Brooks County Commissioner, you need to think about, too, your municipalities and your public works people too, because they have the same problems as well. And I thank y'all very much.
Thank you for your testimonies.
Yep.
I do not see any questions.
Okay.
Thank you.
Great, thank you.
Thank you. Mike Tharp?
Thank you, Madam Chair, and thank you, the committee. I represent Communication Workers of America, and I am a technician for AT&T, and I have 25 years service. I've been working out in the field, and this bill I completely support, and I appreciate Chairman Leverett for carrying this bill. This is my first time speaking up here. I'm thankful for my union for giving me the courage to get up here and do this, but I've had a lot of instances, and one I'll tell you about. I was actually working in Marietta, and I was working on someone's dial tone service, and I went around to the back of the house, and I was just there just for a few minutes, and it was a very affluent area. And when I came around the house, I came back to my truck, and when we park our trucks, we put cones. We make sure our trucks are locked, secured, so nothing's going to happen. No kids are going to play with them. The wheels are chocked, so they're secure. And I walked around the side, the front of the truck to the side, and I heard beating and banging. And I didn't, it kind of surprised me. And when I walked around the front of the truck, I saw my fiber splicing machines going in the front door of a passenger side of a car door. And my brain turned off at that second. I've never had an experience like that where my brain just turned off, and I saw that strap going into that door, and I reached to grab it, and when I did, the driver hit the gas, and I got caught on the door. And I was holding on to the door. I don't know how I ended up there, but I ended up on the door, and the car took off down the road, and I was being drugged on the side of the roadway. And something in my head, I was not in conscious thought, but something in my head said, you better let go, and you better go let go right now, or this is only going to get worse. The lucky thing was his leg, there was two people in the car, his leg was pinned in the door, which I think is what saved me from getting run over from the car. And he drove on down the road. Well, when I let go, he pulled his leg in, and his shoe fell off, so I got a shoe. But I slid to a stop in the middle of the intersection, and he took off down the road, and I laid there for, 15 or 20 seconds, just not even knowing what happened. It felt like an out-of-body experience, to be honest with you. And then a car pulled up to check on me, and then I started checking everything. I just got a little bruise on my leg and a little bumps on my knee. So after that day is when I started to when I started to kind of come around after that, I realized that could have been the end of me right then. I could have been a dead man, because anybody that bold, and they stole my two fiber splicing machines and what's called an old OTDR, a time domain reflectometer. It's test equipment. But they got away with about $12,000 worth of equipment. And I don't know how I didn't get run over. And somebody that bold would probably be carrying a firearm. And I'm just lucky I surprised them, they surprised me, so I'm just lucky that I made it out okay. And it really scared me. It made my blood run cold to think about that, I have a family I got to support. And I really am in support of this bill, because I think of all my other folks, my utility workers out here working, that I want them to be able to make it home to their families. And these folks that are doing these type things, they really need to be more punishment, because we're out here. And I also wanted to mention that we, especially in my end of things, we were walking down the side of the road after hours in the dark, in alleyways, wherever your broadband and telephone lines go, that's where we're walking. And I spent many nights out in the dark by myself, and you just never know what you are going to walk into. But I'm in full support of it. CWA is in full support of it. But that's all I had. I just wanted to let y'all know I'm in full support of it.
Thank you so much, and you did great for your first time, and thank you for sharing your story, and we're glad that you're here with us. So
Thank you so much.
Thank you. All right, Chairman Smith,
Madam Chair, at the appropriate time, I got a motion.
go ahead.
I move to pass.
Do we have a second? Second. All right, all those in favor of House Bill 1033, say aye. Aye. Those opposed, same sign. All right, it passes. Thank you, Chairman Leverett. Thank you, everyone, for sticking through Judiciary, and we'll see you next time. Thank you.